So moving to the July 14th, 2026 agenda, the first item is R277-322, Local Education Agency Codes of Conduct. And Chair, the motion for the board is that the board approve R277-322, Local Education Agency Codes of Conduct, Draft 5, on second and final reading.
I wondered if I'd ever read this. How long has this been in committee, Chair? Do you know?
Too long.
It's been a long time. Yeah, it's finally here. I'm like rubbing my eyes. Is this true? Okay.
Chair, I just want to, it did pass head of committee unanimously with Member Longacre absent. Thank you.
Probably a good thing. No. Okay. The motion before the board is that the board approve R277-322, Local Education Agency Codes of Conduct, Draft 5 on second and final reading. And yes, Leanne just did whisper, I have a motion. So Vice Chair Wood, it better be to send back to committee.
Well, actually, no, as I was reading over this, I noticed on lines 34 and down to 59 that it defines sexual conduct means, and then in 59 it says any sexual conduct or communication between a staff member and a student. We generally don't use the word in the definition, and so working with staff, I would like to move that lines, what was it, back again, 39 and 54 be amended to read, sexual conduct means any interaction between a staff member and student that is sexual in nature, including sexual abuse as defined, leaving those the same.
Can we have that? Sorry, you're using different lines. We're on, I think it's 59. You said 30 something.
Well, there's a big space in between, so.
It starts
on
on
34, sorry.
I see.
I was trying to go back between my motion and what was in there. So just trying to use, I'll wait for a second.
No, you're right. So let's make sure we get the motion, so at least I understand it. Hopefully everybody else is probably already there. But sexual conduct means, and then you jump down to any interaction between a staff member and student that is sexual in nature, including sexual abuse. That's your motion right here. Sexual abuse as defined in section 76-5-404.1. B, sexual battery as defined in section 76-9-702.1. And C, sharing sexually explicit or lewd communications, images, or photographs. That's the motion. Is there a second? There's a second. Go ahead, Member Wood, Vice Chair Wood.
Yeah, sorry, I spoke to it again. Just that not using sexual conduct in both the definition and the word. So that's my motion.
Not seeing any additional lights. Let's go ahead and tee that up and put it to a vote. That passes unanimously. Okay. So the motion is that the board approve R277-322, Local Education Agency Codes of Conduct, Draft 5, as amended on second and final reading. Let's vote. That passes 13 in favor, 1 absent, 1 abstention, the abstention coming from Member Bogus. Back to you, Chair Carey.
Thank you, Chair. The next item is 7.3. That's R277-301, Educator Licensing. And the motion for the board is that the board continue and approve R277-301, Educator Licensing Draft 2 on second and final reading. This passed out of committee unanimously by all those present.
Thank you. The motion before the board is that the board continue and approve R277-301, Educator Licensing, Draft 2 on second and final reading. Member Bogus.
Sorry. Thank you. I have a question in particular for Director Height, if she's available. She knew this was coming. I forewarned her. Did I get it right, Director Height? Oh, Executive Coordinator Height. There you go. I tried. Okay, so as we look at lines 52, 53, 54, 55, we're moving these to Doppel, as I understand it. Can USBE track the ethical violations of these individuals as this is written?
Chair, if I may. I'm Malia Hyde, Executive Coordinator of Educator Licensing. I'm happy to assist. So with the law that took place, HB 347, this last session, they moved all SLP, speech language pathologist, and audiologist licensing to Doppel. So we have currently some licensed SLPs and audiologists, and because a license is a property, they will hold that license until it expires. And at that point, they will have to go to Doppel. Anyone who has a USB educator license falls under the supervision of the board and must comply with educator ethics and the UPAC process. Anybody who has only a Doppel license is not subject to those standards.
Yeah, that's a problem. That's a very big problem, actually. I don't know if anybody else is shaking their head inside, but that's a huge issue that we have people inside our schools that are not subject to our process or our accountability or even our rules. Yeah, just like the Catalyst Center. I think it's a great comment. And so I understand this comes from code, but I have huge issues with this. In fact, the only board rule they would really be subject to is probably 322, which would be am I correct in that assertion? Yeah, so please answer so I don't say Executive Coordinator Height just shook her head because they don't know which direction you shook it.
Yes, that's my understanding, that they would be, as employees of an LEA, they would be subject to the LEA Code of Conduct Rule R277-322.
Okay, thank you.
Okay. So the motion before us then is that the board continue and approve R277-301, Educator Licensing Draft 2 on second and final reading. Seeing no additional lights, let's go ahead and vote. There we go. Okay. That passes 10 in favor, 5 opposed. Those opposed being Member Booth, Member Davis, Member Kelly, Member Green, and Member Bogus. Back to you, Chair Carey.
Thank you, Chair. The next item before the full board is 7.4, Teacher Preparation Programs. And the motion is that the board approve R277-304, Teacher Preparation Programs Draft 1 on second and final reading. And Chair, I do have a question for Dr. Height regarding this matter. Thank you.
Okay. Draft 1 or 2? I've got Draft 1.
I have Draft 1 as well. But
from August, draft 1 from June.
it does say, yeah.
maybe we can get some clarity on that, but let me read what came out of, do you remember saying draft 2 out of committee?
Oh, you're on 306. She's on 306. We're
306 has a draft
yeah.
2.
This is 304.
Okay.
Draft 1, Chair.
So, okay, so the motion that came out of committee before we get to the question is that the board approve R277-304 teacher preparation programs draft 1 on second and final reading. And back to you, Chair Carey, for your question.
Thank you. And Dr. Height, this is something that we were, through the chair, this is something that we were discussing during lunch. Is there any provision in 304 that expressly prohibits a for-profit entity from providing an educator preparation program?
Thank you, Chair. Malia Height, Executive Coordinator of Educator Licensing. So 304 does not have the provisions of who can and cannot be an educator preparation program. That is in R277303, the educator preparation program rule. So this rule is only for teacher preparation programs that must also meet the educator preparation programs. So all educators include school psychologists and school counselors, while this rule is focused to the requirements that a teacher must meet in order to obtain licensure.
Okay. Thank you, Chair. Thank you, Chair.
Thank you. Seeing no additional lights, let's tee this up for a vote. And the motion again is that the board approve R277-304 teacher preparation programs, draft 1 on second and final reading. Voting is open. Thank you. And that passes 13 in favor, 2 opposed, those coming from Member Kelly and Member Davis. Back to you, Chair Carey.
Thank you. The next item is 7.5, R277-306, educator preparation programs for school psychologists, audiologists, speech language pathologists, speech language technicians, counselors, and school social workers. And the motion before the full board chair is that the board approve R277-306, educator preparation programs for school psychologists, audiologists, speech language pathologists, speech language technicians, counselors, and school social workers, draft 2 on second and final reading.
Okay, the motion is that the board approve R277-306 educator preparation programs for school psychologists, audiologists, speech language pathologists, speech language technicians, counselors, and school social workers, draft 2 on second and final reading. Seeing no lights, let's put it to a vote. That passes 12 in favor, 3 opposed. Those opposed, Member Green, Member Bogus, and Member Kelly. Back to you, Chair Carey.
Thank you, Chair. This is item 7.6, R277-101, public participation in Utah State Board of Education meetings. And the motion before the board is that the board continue R277-101, public participation in Utah State Board of Education meetings. And I do have a motion on this, Chair. Thank you.
Okay, so the motion is that the board continue R277-101, public participation in Utah State Board of Education meetings. Back to you, Chair Carey.
Thank you, Chair. And the language would be that any comment not permitted to be made during the public comment session portion of the meeting will be available in backup and labeled as potentially explicit or offensive. And with a second, I would speak to the motion.
Yeah, do we have a second? We got a second? If you'll speak to that, the question was, so just know it's coming if you didn't plan to speak to it, where does this go?
Yeah, and we can just add it to the very end as a new heading. I mean, I can come up with a. So, Chair, I would just add it to line 81, and the title would be Prohibited Public Comment, and then it would be followed by this language.
Feedback, Chair, that it might be better suited maybe at the end of public section 3 titled Public Participation.
So I will ask you what I asked my wife. If you had the answer, why did you ask me the...
That's a great question, and I got it from these two ladies sitting on the side here.
That's fine. That's a fine place to put it, Chair.
Yeah, it sounds like we're less concerned about where it is, but we want it in there. Go ahead and speak to the motion, and then we'll open up for questions.
Yeah, and I'm sorry, it should say any comment or materials not permitted to be made or shown during the public comment. But just speaking to it, generally this comes up because what someone from the public wants to share during the public comment section violates this board's rules of decorum, that we don't want them speaking and sharing things that many times we have students in the room, we have people listening online, and so the chair will ask that they not share it and that they submit it to the board. And the 3 times that that's happened since I've been on the board, the speaker will generally have a printout of what they wanted to read, which is typically a book found in one of our public school libraries. And they will disseminate that to each member at this table. Well, that's not really public comment then, because every other public comment you can listen to anywhere in the state. And you can find out, wow, that's what they wanted to share. That's what they wanted to say. But when we only give them the ability to share that with us, that generally stops with us. They can't really share it with the entire body, with the entire listening audience. So when I was first discussing this to see, well, would it be better just to change our rules of decorum? I mean, if this book is in our public school library, why not just have them read it out loud? I mean, it's available in our schools. But I did think that we are a different body, and I thought it would be best, instead of them just having show the materials or read the materials in real time, that if we permitted them to put this into backup with this label, so people know if I click here, there's going to be something that maybe I don't want to see or don't want to read, that would still permit them to exercise their constitutional First Amendment right to put this information out to the system, to the body, because otherwise they're limited to just giving it to us. And that would be the same as if we have a speaker come to the podium, we usher everybody outside the room, we turn off the broadcast and say, okay, now share your public comment. The 15 of us will hear it and then resume the meeting. That's really what we're doing when people want to share something in public comment and we cite our rules of decorum. They're really sharing that just with us, and we are treating them differently because of the content they're seeking to share. And generally, you can't do that as a government body. So if they want to come in and talk about anything else, you can tell the board, you can tell the audience in the room, and you can tell the people listening online. But if it violates our rules of decorum, then the only people you're allowed to tell, it's the board. Not even the people in the room get to see it. It's just the board. So that's the purpose behind the motion, Chair, which is I was trying to find this balance between do we really push as a body to say, look, the First Amendment, we should treat their speech just like anyone else? But again, given those nuances, I felt this allows them to put their information out there. So if a member of the press wants to see what's wrong with that book, what were they trying to share, they can access it. Otherwise, it's just the 15 of us. And I believe we're treating speech differently based on its content. I don't believe that's appropriate when it's not the least restrictive means. And to me, this meets that because we're providing an outlet for it instead of just really saying you can't share that with anyone but the board. Thank you, Chair.
Thank you. Before I call on you, Member Davis, I have a question, if that's okay. I actually, not actually, like, I actually support this. No, I do support this. But I do have a couple of questions that could be helpful. One, the timing. We've already seen some backups, you know what I mean, be uploaded. And so I don't know how to say, okay, Sybil, if something comes in, you're going to republish. So I'd like to have an expectation. Of course, similar, even if we said it was similar to ours, right? And ours is, if you remember, staff is last Tuesday, or Tuesday of last week by 5. Ours is Tuesday of this week by 3. And so I would probably hope that we could put the public in that range as well, right? Because I can't have Sybil uploading this morning when they say I need a public comment. The other thing, if I could keep that in your mind, is timing. The other thing is many of you don't see the conversations that sometimes I have to have with individuals and maybe Sybil, specifically on things like UPAC cases, where I say, you're welcome to share public comment. That's your right. But be aware, right? Understand that these are some complications that could come forward. So when we open it up to any comment or materials not permitted to be made or shown, there is some concern, not only to protect us, which I'm not worried about protecting us. I'm actually worried about protecting the public commenter. So, thoughts?
Thank you, Chair. If I understand the first question correctly, I don't think that would be an issue in the sense that they would not be required to preemptively upload anything. It's not until they're at that podium and start to speak and the decision is made, what you're sharing would be a violation of our rules of decorum. At that point in time, whatever they wanted to share would go into backup.
I know I hate to have a one-on-one here, of the current month or of next month's?
I would defer to staff on that. I mean, I don't think because it would depend on when they can get that to Sybil, when they could get that to whoever's responsible for putting it into backup. But right now, whenever that timeline would be better than what we currently have, which is they're only talking to 15 of us. So I would say, to the extent that we can accommodate that, but nothing would be preemptively uploaded into backup. This would be, okay, we see where you're going with this, and our rules permit this to be put into backup. Currently, it does not, and that's where I'm looking to go. As to your second point, and then Chair, to the extent I'm allowed to make an amendment to my own motion, I could, but I think you bring up a valid point, which is I don't think it's open house on anyone who wants to stuff things into backup. And I do think that this motion could be improved by adding, not permitted to be made or shown due to the board's rules of decorum. And that way, it's not just anyone coming in and saying, I want to put this in, I want to get this out. That determination would initially have to be made that this violates our rules of decorum. And if it doesn't, they can say whatever they want to say straight from the podium.
If I can still, Cindy, if it's okay, I'd like to amend the amendment to whatever Joe just said. Is that a thing? Okay. Well, let me put this amendment in there, then we can vote up or down. That will open it up for another amendment. Is that okay? Can you make that point, Vice Chair Wood?
Staff was just pointing out that our civic clerk is a backup with a 24 hours at least notice to public of what's going on in a meeting, a future agenda item, that this may be better put in as an addendum to our meeting minutes. So that shows what was happening in the meeting at that time, rather than trying to go back to backup, which is a forward-looking thing.
Chair, if I may, I just have a question. I have no opposition to that as long as the minutes are available online to the public as well. And if they are, then I don't have any objection to that.
Okay. So my motion then, my amendment to this is to add any comments or materials not permitted to be made or shown due to the board's rules of decorum during the public comment portion of the meeting will be updated or made available or be available in meeting minutes and labeled as potentially explicit or offensive. I guess the potentially offensive would be more, because if it's explicit, it's explicit. If it's offensive, it's potentially, depending on who you're talking to. But I'm not going to nitpick. I'm just, as I'm reading through this, trying to, but I think that's my amendment to, that would be my amendment to Member Carey's motion. Let me make sure that captures it. And Member Carey, I'd ask that you kind of look at this as well and make sure that makes sense. Go ahead, Cindy, shout it out. So you're gonna give me suggestion on my amendment because I don't even have a second yet.
If you'd
So-
consider adding the word policy related before you get a second. So it would be any, going back up to Member Carey's, any comment or materials not permitted to be made, but it would say any policy related comment or materials. I think this is mostly for like our materials in our schools and things like that, in our libraries, and that would all be related to policy materials. But if someone comes in, like a couple years ago, we had a guy that would come in and make threats against our former superintendent, like just big time, and that kind of stuff I don't think should be put in. Well, that's a whole nother one too. The Exorcist, that kind of stuff probably shouldn't be put in.
I will put that in my amendment. I know we're speaking to a
Yeah.
lot here, but I agree with you here.
That would be helpful.
My
Thank you.
amendment to Chair Carey's amendment is that the board amend this so it would read any comments or materials not permitted to be any comments or materials, any policy related comments or materials not permitted to be made or shown during the public comment portion of the meeting due to the board's rules of decorum will be available in meeting minutes and labeled as explicit or potentially offensive. That's been seconded. It's been stated. Let's vote on it. All right, voting is open. Okay, that passes unanimously. So we go back to the amendment, which we've kind of rewritten. So I'm going to ask, it's going to be the same thing. I amended his amendment, so the amendment is now as we just voted. So is there, I see, remember, Carrie, you have a light on, but is it for this amendment? I'm going to ask, so we don't have to go through that entire process, is there any objection to this being the final amendment? Not the final amendment, but the amendment. This is the wording that's going to be in the where do we have, policy or rule? Rule. This is the verbiage. Is there any objection? Okay. With that, we are on, okay, let me restate the motion to reset where we are, then I'm gonna, because we do have other comments, or questions or emotions. The motion is now that the board continue R277-101, public participation in Utah State Board of Education meetings as amended. Vice Chair Wood.
Yeah, I have a simple motion to strike lines 73 through 78. And with a second, I'll speak to that. No second.
Everybody's reading it, so it's not that nobody's seconding it, it's just. Okay, so the motion is to strike lines 73 to 78. It's on the screen if you haven't read it yet, or if you're currently reading it. It's been seconded, I believe. Go ahead, Vice Chair Wood.
Thank you. As I was reading this, I realized it says that in order for us to have an electronic meeting, that we waive the requirement to have a quorum present in a single anchor location in the event of a pandemic or other public emergency. Well, we do have electronic meetings. We don't have a single anchor location. And as I followed up with staff, I learned that this was language that was once in a model policy and statute around the pandemic time. And so it's kind of old language. And so I feel like lines 79 and 80 are sufficient. If the board conducts an electronic meeting, any member may participate and vote electronically so long as the board meets quorum requirements, which means that we have 8 of us. So 73 through 78 are no longer needed.
Member Carey?
This probably, I think, more appropriate for staff, but does this mean that if leadership decides, well, we shouldn't be meeting every month in person, we're just going to meet electronically, by doing away with this language, would that facilitate that taking place? Like right now, the way I read it is, for any meeting of this board, at least 8 of us have to be in person. If we do away with this, then there wouldn't be a requirement for any of us to be in person. We could hold our board meetings all virtually. Would that be correct? And if that assumption's correct, would we ever have to meet in person, or could we just have every meeting every month virtually?
It sounds like on line 75, notwithstanding subsection 3, the board chair may waive the requirement that a quorum be present at a single anchor. Sounds like I could do that anyway. I say the board chair, right? So I don't think that this language does anything or would.
It doesn't do anything differently than the chair could do today.
That's what I'm thinking.
Okay. Thank you, Chair.
Thank you. Okay, so the motion is to remove lines 73 through 78 from the policy, or from the rule. Let's go ahead and vote on that. Okay, that passes 14 in favor, 1 opposed, that coming from member Carey. That brings us to the underlying motion, and that is that the board continue R277-101, public participation in Utah State Board of Education meetings as amended. Is that right? Should I move something? And approve. Oh, does it?
Since we made amendments, yeah, we updated.
Oh, the motion is that the board continue and approve R277 -101, public participation in Utah State Board of Education meetings as amended. Okay, let's go ahead and vote. Okay, that passes unanimously. Back to you, Chair Carey.
Thank you, Chair. The next item is 7.7 R277-409, public school membership and associations. And the motion before the board is that the board continue R277-409, public school membership and associations. This motion passed unanimously from law and licensing by all those present.
All right. The motion then is that the board continue R277-409, public school membership in associations. Member Bogus?
I'd like to amend line 29. And staff has the motion up there that we would strike beginning in the 17-18 school year. And after the word if, or after the word with, we would add Utah code and R277. I think we need the word and in there, Superintendent Nui.
Okay, so there's the context. So it would now read, a public school may not be a member of or pay dues to an association that adopts rules or policies that are inconsistent with this rule, right, with this R277-409-3 and Utah code. Okay, is that right?
Yeah.
Okay. Is there a second? There's a second. Go. Okay, back to you, Member Bogus.
Thank you. I think this brings us to our all-encompassing thing. We've recently had the legislature pass a few, and there are some that are currently existing that really need to be implemented in this area. And so I think it just puts us in a place where we draw attention to it and says that if we're doing business and paying to these associations, they are in compliance with our legislative code in this state. So I think that would be the synthetic version. I can expand if you would like me to, Chair.
Thank you. Member Earl. Member Lear, I thought you'd speak to this. You said, oh, shoot, you were all queued up. I've got Member Earl, but, oh, okay.
Oh, and that's what I mean. And Utah code. It just seems like it's very broad. I guess it doesn't matter then, right?
From what I understand, it just means that these associations need to make sure that they're in line with our rule and the law. Yeah. Okay. So this is an amendment, and we are striking the words beginning with the 2017-2018 school year and adding the words and Utah code to the end. Member Davis.
I'm just reading the context. So if there's a local membership of an association and it has a national component, does that preclude? Like, for example, someone said to me once, why is USBE a member of NASB? because it has some national opinion that is different than how we feel in Utah. And there are two schools of thought. One is that we're being influenced by them, but the other is that we have great things happening here and we can influence them. And that is why we go and participate and share. And so does this preclude that? Like if they are a, member of the local whatever and they have a national component, does it preclude them? Does it get rid of all those then associations, state associations?
Yeah, that's a good question, because I don't know what their rules or policies would be that would dictate. Does an association dictate with their rules the rules of the LEA? Speaking of NASB specifically, as a member of that board, we have made sure I've sat there and had a conversation saying, we are not taking positions. You have red and blue states alike in NASB, and that's your point with this national thing. I said, we need to stop taking positions. Feed us information, right? Unbiased information. So but as far as their rules or policies, do they dictate what we do? No, they dictate what they do. So
Here's another
yeah.
question. If there's an association there's a lobbyist association like the Teachers Association, and if they have a policy that's different or they advocate against or they advocate the legislature to change something or something, then does this make it illegal for them to be involved in those associations?
Member Bogus.
The answer is no, because it would not be, it says a public school may not be a member of, and the EA, the teachers are a member of, so there's a distinct separation. We're talking about the LEA in particular, and right here, we're not talking about the USBE, we're talking about public schools.
Would that be like the school board of an LEA?
Say it again.
Like the school board of an LEA?
So it's, I don't know that it means the school board, but it does say a public school may not be a member of or pay dues to an association. So yeah, it would be the board. I think it's written kind of funny, but I opted not to go all into the minutia. You should be proud of me, even though it prompted a question.
It doesn't say
You
the
should
board.
be proud
it
of
says
me,
a
even though you
public
asked a
school.
I
question.
mean, a school is an inanimate object. A school can't do that anyway, so it doesn't even make sense.
So what if we just, why don't we just say an LEA? I was going to avoid that amendment. I know you're very proud of me for avoiding that amendment, but since it prompted a question, without objection, an LEA may not be a member of or.
Yeah, I just don't. I hope it doesn't have unintended consequences. If that component has a national component, then they.
Yeah, I think to your, I guess you're saying, can an object, a school, be part of an organization? And the answer, we believe, is possibly yes. And a glaring example is the UHSAA, is what we're hearing, right? Because even within, and I get that if you say LEA, that's encompassed, that's fine. But your elementary school is not going to be part of that, but your high school will be, right? So it does, I do believe it still works, a public school. If you change it to an LEA, I don't think that that's going to break anything, but did that just send you deeper into the mud?
It just doesn't help me with my, like, what about USBA? So I don't know, it just moved forward. I can let it
Okay.
go. I'm not going to vote for it, but.
So here's where we are, because Elise, and I'm sorry, we still have a public school on there. We haven't done anything, but it's a public school may not be a member of. No, I'm not saying to replace that. I'm just saying what was before the body is the phrasing: a public school may not be a member of or pay dues to an association that adopts rules or policies that are inconsistent with this R277-409-3 or Utah Code. Member Lear, to this motion.
I feel like a little like Christina. I don't want to make this more complicated, but this was a rule designed to address issues 10 years ago with UHSAA. And my recollection is, I should know this, but it's not LEAs that join UHSAA, it is schools. And they are treated individually in within the context of UHSAA. So I think we stick with that understanding. Well, because they can't. You can't target a specific private organization, but that was their intent, and at the time, and special legislation of sorts, only in rule form, and so that was the point. And I think that although it's odd that it's appropriate to read a public school may not be a member of or pay dues to, comma, if you don't mind adding in that comma, an association that adopts rules or policies that are inconsistent. I think we just stick with the public school for now, and I don't want to make it more complicated, but let's be honest and say this was about some concerns that the board and the legislature had about UHSAA, and this was the compromise from 10-ish years ago.
All right. So the motion before us, let's tee it up for a vote, is to strike beginning with the 2017-28 school year and add or Utah code. So let's go ahead and vote. That passes 13 in favor, 2 abstentions, those coming from Member Green and Member Davis. This brings us back to our underlying motion, and that is that the board continue R277-409, public school membership in associations. Let's go ahead and, as amended, sorry. So we need to say, the motion will now say that the board continue and approve R277-409, public school membership in associations, as amended. Let's go ahead and vote when that's ready. There it is. Okay, that passes 14 in favor, 1 abstention, and that comes from Member Davis. Board members, let me ask, in that last conversation, there are 15 of us, and I think there were 7 side conversations. No, it's fine. What I'm reading is we may need a 5-minute break. Is that okay? Let's do it. Yeah. Yeah, let's set a timer for 7 minutes. Thank you. I also need Chair Carey, and I don't even have Vice Chair Bollinger of that committee, but I do want to get started. There's Chair right there. Okay. And Chair, I can't turn on your mic. I know, I'm calling this back to order so we can get going. Okay. Okay, Christina's good.
We don't have a quorum?
We have a quorum, but for some reason, this side of the table.
5, 6, 7. Oh.
There's 9. 10. Hey, man, it's all in here. Oh, there's your okay, what's coming up? I thought there was like a party out there. All right, Chair Carey, whenever you're ready. If you want to wait for a second, that's fine. Just whenever you're ready, though.
So, Chair, the next item is 7.9 R277-211, Utah Professional Practices Advisory Commission, UPAC, Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions. The motion before the board is that the board approve R277-211, Utah Professional Practices Advisory Commission, UPAC, Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions, Draft 1 on second and final reading, and I do have 3 motions on this. Thank you, Chair.
All right, so the motion that came out of committee is that the board approve R277-211, Utah Professional Practices Advisory Commission, Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions, Draft 1 on second and final reading. And Chair Carey, back to you.
Thank you, Chair. My first motion is on line 40. It would actually be to create a new line 40 that would read, and it's right there listed as number 1. It would read Roman numeral 4, the names and contact information, if known, for any witnesses. And with a second, I would like to speak to that motion.
There's a second. Let me just make sure we're in backup. We've got the draft 2. That's what came out of committee. There's a draft 3 in backup that says
Draft 1 came out of committee.
draft 1 came out of committee. Which draft are you adjusting here?
Draft 1.
Okay,
The one that
so
came
I
out
can-
of committee, Chair.
Okay, thank you. And then we are on, as you said in here, I don't know what line that is, but it's section 2, subsection 2B, IV or 4. And you want to include or add the names and contact information, if known, for any witnesses. It's been seconded. Go ahead and speak to that.
Sure. And I'm looking to create, if you look at line 39, Roman numeral III, school or LEA, I'm just looking to create a Roman numeral 4 with this. And right now, if you read lines 30 through 39, when someone files a UPAC complaint, they have to provide this information if it's known. Their name, their position, the telephone number, address, all these things. The one thing that we don't expressly require or request is the names of any witnesses or witness to the allegation that's being made. And what's happening is that it presents the opportunity for a determination to be made as to whether or not there should be an investigation without the opportunity to conduct these investigations ahead of time, to look at and see, are there witnesses that should be contacted? Are there witnesses out there that we should be contacting? So by requiring this information to be listed, I think it provides UPAC with information very early on about the existence of any witnesses who should be contacted. Does not require that they be contacted, but it certainly provides notice that there are other individuals who may know something about this matter. Thank you, Chair.
Okay, so the motion is to add a new line in in line 40. This is before, this would be 4 or IV, the names and contact information, if known, for any witnesses. I don't see any lights, so let's move this to a vote. Oh. All right, no, it's not your fault. Member Kelly, go ahead.
Yeah, I want to speak in favor of this motion, but I do have a question for the maker of the motion, and I'm curious if we need to differentiate the witnesses. I'm concerned about that students, versus adults, and do we need to differentiate that the witnesses that they should be adults? I don't know that we want UPAC investigators going in and interviewing students and minors. So.
Sorry, I can't give you a mic. sit in silence for a while. Okay. Member Carey, please.
Thank you. No, and that's a legitimate question and concern, Board Member Kelly. But there are several instances. The one that is top of mind is following the death of Charlie Kirk. There was a UPAC matter filed about was something said in class by the educator or not. The witnesses to that educator were students in the classroom. And so in that sense, there was no other way to really determine was this said or wasn't it said. And Board Member Longacre had a similar concern. I want to make it clear that this information is confidential. It's not provided to the public. This is housed within the UPAC system. And again, it is just to alert UPAC that it doesn't have to be reduced to a he said, she said, that there may be witnesses to this matter. And I think UPAC's internal processes do permit them to exercise judgment in terms of who to contact, who not to contact. And one of them, I believe, is based on their age. Thank you.
I don't see any additional. Let me restate the motion here, and then we will move to a vote. The motion is that the board amend draft 1 by adding to the list in R277-211-2, paren 2, paren B, a new line 40 that reads paren 4, Roman numeral 4, the names and contact information, if known, for any witnesses. Let's go ahead and vote. That motion passes 9 in favor, 1 abstention, 2 no votes, and 3 absent. So for abstention, I've got Member Davis. No votes are Member Hymas and Member Lear. And Member Carey, I believe you have some additional motions. Go ahead. And I can't. There you go.
Yep, I do. Thank you, Chair. The next one, if you go to line 133, there would be line 133 would begin with, this would really be like 7A, and it would read, the educator shall be notified of their right to receive a copy of the UPAC case file and UPAC evidence file at no cost in writing. B, if additional information is amended to the UPAC case file or UPAC evidence file, these materials shall be provided to the educator without request and at no cost. And with a second, I would like to speak to that.
Can we get that on the screen? I just want to make sure. I've got A and B. Member Carey, are these your motions?
Yes, sir.
Okay. And it's got a second from Member Kelly, is that right? Okay, back to you.
Thank you, Chair. Currently, if you look at line 131, if we could call that up on the screen, our UPAC rules already require that upon the request of an educator, if you're in UPAC and you request this, you have to be provided with it. And you get two things when an educator, when a teacher makes this request. UPAC is supposed to send that educator, that teacher, a copy of the UPAC case file, and on line 132, a copy of the UPAC evidence file. That's already in our rules. As we've looked into UPAC, it became apparent that educators weren't receiving these two files or these two subparts of their file, in many cases because they just didn't know they were entitled to ask for it. They just didn't know, wow, I can just ask for this and UPAC gives it to me. So this rule would just not require the disclosure of any additional information that the teacher is not already required to receive. It would simply require the executive secretary to notify the teacher, the educator, of their right to receive a copy of these things and add the provision, as we do now, that it be provided at no cost. That's currently not a protection that we have in our rule. It's my understanding we don't charge for this. I'm just saying let's put that in rule so we don't charge for the providing of this material. The other thing, and this is in B, let's say that the educator requests a copy of their case file and their evidence file in March, and UPAC dutifully gives them their case file and their evidence file in April. Well, in May, UPAC receives 22 more pieces of paper that they put into the evidence file. Instead of requiring the teacher or educator to write UPAC every month and say, hey, did you receive anything new? Could you send it to me? B is an automatic trigger. And what this does is this allows or requires that UPAC, when it receives additional information, that it provide that information automatically to the educator. This is typical in a discovery in a legal setting, that once you request information from the opposing party, that if additional information becomes available, you're obligated to provide that to the other side. You can't hide behind the, well, you never asked me for this. So this really brings us into a practice and a system that's already in place in the legal or adversarial system, which UPAC is. So again, not requesting any additional information be disclosed. A just simply says, hey, the educator has the right to this stuff. We should let them know they have the right to it. B says, once you give them that information, if you get more, you've got to turn it over. We can't play the, well, you didn't ask for it, so I didn't send it to you. Thank you.
Member Lear.
I have a comment and then a question to Executive Secretary Rasmussen, UPAC Executive Secretary Rasmussen, if I got that title right, if that's all right if we call on him. I think it's unfortunate that we weren't able to discuss these amendments, these proposed amendments in our committee meeting, because I would have liked to have heard a little bit more about the burden on the staff that's clearly understaffed and more understaffed than it was a month ago. And if this, how much this is going to add to the workload, and if this is doable, if Ben says it's doable, then I can live with it. But I do think it's unfortunate that we couldn't discuss this and get more information in a committee meeting rather than have to now be not have as much information as I would like. So to you, Ben, if it's okay through the chair. Is that okay? How much would an automatic provision of this sort, is this possible for you given your staffing? Does it change your practice much? If you tell me no, then that would be helpful, but I'd like to hear an honest response.
Ben Rasmussen, Director of Law and Professional Practices. This doesn't concern me at all. This is already our practice.
Great. Thank you. What I wanted to hear.
Member Earl.
I'd like to make an amendment, and it's an organization amendment. It's not amending the content. It would seem to me that A actually should be 7, and that 7 should be A and B. Does that make any sense? Like the parameter should be the executive secretary shall. That should be what 7 states, the overarching, and then the provision of upon request of an educator, that should be A, and B should be the executive secretary, because those follow underneath. You get notified, and then after the notification, if you ask for it, then does that make sense? I'm just saying the ordering's off, and I don't know if that's an amendment or if that can be fixed after, at least in my view. But I don't know. Should we pass this first, and then I'll make that motion?
I don't want to beat up too much. We've already beat up on where things should go in a motion. So I hear what you're saying, and I think
It's disordered.
where it's placed in there would be appropriate. If we want to take a vote on how to place it, fine, but I'm fine with what you're saying. Like, let's put it where it belongs. I think the meat of
Okay,
this,
the amendment
of course,
to be ordered accordingly. Yeah.
Yeah.
So I'll just put that.
So your motion is that the amendment be ordered accordingly. Is there
Yeah.
any opposition? It's been seconded. Is there any opposition to ordering that? Okay.
Okay.
Let's go ahead and go back to the meat of this. Thank you, Member Earl. Let's go back to the meat of this. And the motion then is let me just make sure I get it. That the board amend draft 1 by adding, and I'm just going to say adding, 7, the executive secretary shall notify the educator of their right to receive a copy of the UPAC case file and UPAC evidence file at no cost. Paren 9, the executive secretary shall be under a duty to continually disclose additional evidence added to the UPAC case file and UPAC evidence file until the matter is resolved. Member Lear, is your light back on?
I do. I have another question.
Sure. Go ahead.
Realize that we have no definition that I can readily see on case file and evidence file. And I'm wondering if that is something that Ben believes is easily understood, or if it's something that we need to define.
Director Rasmussen.
If I may. Yeah, those terms are defined in R277-210.
Okay. In a different rule or
We
in
have
the
we have the UPAC
definitions in
rule.
210. So they are both in there.
Yes.
Thank you.
Okay. Seeing no additional lights, I'm going to, I just restated the motion. We're going to tee this up for a vote. So let's go ahead and get that ready to vote on. Okay, voting is open. That passes unanimously. Thank you, with 2 absent. Okay. One more? Go ahead, Chair Carey.
Thank you, Chair. The third and final amendment that I have is to it says line 66, but that doesn't look. Is it line? Oh, look at the screen. Okay, sorry. That the board amend draft 1 by adding to the end of, at the end of R277-211-2. As Board Member Baga said, that would take us to line 60. And the motion is that the superintendent shall establish an online searchable database of each UPAC case decided by the board that results in the revocation or suspension of an educator's license. 8, the database shall include A, the name of the educator, B, the name of the school where the conduct occurred if applicable. C, the name of the LEA where the conduct occurred if applicable. D, the disciplinary action issued by the board. And E, a brief description of the conduct that led to the disciplinary action. 9, the superintendent shall comply with any federal or state privacy laws in including information in the database and shall remove information if required by law. And with a second, I would like to speak to that, Chair.
We've got a second. Go ahead.
And Chair, can staff, whoever's driving, can you go to the Utah Division of Public or Professional Licensing, the Doppel site? Is that possible? There we go. And so if you're in another profession in the state, your licensing isn't generally controlled by, like us, we control education, lawyers control the licensing for education, and the doctors have one for themselves. But a lot of professionals fall under Doppel. And if you have a contractor that you want to hire and you're wondering, has any action been taken against them, you would come to this Doppel site. And I just want to do an A-B comparison because Doppel is very streamlined in terms of, wow, let me search, is this contractor I'm hiring, have they have any action against them? And whoever's driving, if you could just scroll down. And right there, that orange, it says search for disciplinary action. Nope, one more down, right there. So you go to the Doppel site, you're one click in, and if you click that button, and we wait for refreshing, this is it. And I'm not going to ask anyone to type in a name, but you type in someone's name. If they've had a disciplinary action against them of a certain magnitude, you would see their name pop up. You would see when that action was taken. You would see what the action was taken for, and a 1 or 2 sentence summary of that action. And that tells you as the consumer, wow, this is somebody that I may not want to invite into my home. This may be someone I don't want near my children. And Doppel does this at a magnitude far greater than USBE with the teachers. If you are only 3 steps into the Doppel site and you have visibility on these individuals, if you go to the USBE site, do you know how to find the information whether an action was taken against an educator? You're about 9 clicks in before you can identify the educator. So what I'm proposing is that right now our disciplinary actions that we take as a board are integrated into the Cactus system. And Cactus really isn't designed for the public. It was designed for educators. It was designed for LEAs in schools to look up, does this person have a license? When did they get it? When does it expire? So what I'm proposing is that we have, as does the lawyer body, as does the medical body, as does the accounting body, a separate pathway for non-educators to simply look up and find which educators have had, and this is important, not any disciplinary action. If they had a letter of reprimand, wouldn't be in this system. If they had a letter of warning or a letter of education, would not be in this system. But it would contain, when this board takes action at the suspension level or revocation level, it would allow the public to look and see that action in this database. And the information that would be required in the database, and can I just ask who's driving if we could just go back to the motion? The information that would be contained in that database would simply be the name of the educator, the name of the school where the conduct occurred, the name of the LEA where the conduct occurred, the disciplinary action. So did we revoke? Did we suspend? If so, for how long? And a brief description of the conduct that led to the disciplinary action. Also, I think provision number 9 is very important. If there's any information that should not be posted, this gives the superintendent the discretion not to post. It also must comply with the state privacy law, which I believe says after 10 years, any disciplinary action taken against anyone, not just educators, but in the state generally, has to be removed. So this isn't, hey, once you're there, you're there forever. This provision allows for the removal of that information. I think it's important to increase transparency. There is this black hole of information when parents want to find out about the teachers that are teaching, that'll be teaching their kids, their grandkids, their neighbor kids. And also, there's this hole where we can't see, are some schools and some LEAs better in their processes and procedures? This system gives that awareness to the public. And I think that's absolutely essential in beginning to restore trust of the public in public education. Thank you, Chair.
All right. Okay, you're gonna wait? Okay. You were next. I know, I've got a list. If you want to wait, that's fine, but, okay. Member Bogus, go ahead.
Thank you, Chair. Member Carey, I really like this motion, but I have some concerns. One, I'm concerned that it's going to narrow the scope, because if you go to cactus.schools.utah.gov and then there's a person search, you can already search the Cactus database and you can find out if a person you're searching for has a reprimand on their file, if their license is expired. There's already a lot of information, and you actually can find out not B and C, but you can find out A and D in terms of this already. And my concern is that by passing this, we would be giving less information to the public in terms of that searchable database that already exists. So I don't know that we need to create a new database. I think we need to expand the existing database, because there is already one, unless that has been suspended through the USIMS process, and I'm unaware of that. I'm seeing heads shaking no that it's not been suspended by the USIMS process. So for some reason, it's not pulling in this moment, but it is cactus.schools.utah.gov /person search. And there's a lot of information there. I think if this is the direction we want to head as a board, I'm in favor of that and of that transparency. I just don't want to go backward as opposed to going forward.
Yeah, we do have I'll put you on here. We're going to have a long list of commenters. I'm hesitant to get into a comment back and forth, and then I'm going to wear you out. You know what I mean? So go ahead here, and then we'll put a rotation on there. So go ahead, Member Carey.
No, I think Board Member Bogus has a legitimate concern. Nothing in this proposal would eliminate the requirements currently in the system that we have. If Cactus requires that a reprimand be listed or a letter of warning, it can continue to do that. I think one of the great failings of our current system is it will just say reprimand, it will just say suspended, and there's no insight into the why. And I think that both hurts and helps educators, but I think the public's entitled to know the why, and I think that's why provision E is so important. But to your point, nothing in here would stop Cactus from operating the way that it does. So if Cactus wants to continue to report on reprimands, they can continue to do that. The system I'm proposing, this disciplinary database, it would not. The other advantage is that it allows you to search by school or LEA. So if my child is now going to a new school, they can see across the board what disciplinary action in this school has taken place and against whom. And I think that's absolutely important for transparency. Thank you.
Follow up.
Just very quickly, I really do appreciate that, Board Member Carey. And just a brief question. So 312 establishes this database. I believe we already have a rule on an established database. And my question would be, is there a reason that we're putting this in 211 instead of into 312 that already has an established database? And maybe I'm wrong in that, but if somebody could prove me wrong and make me smarter, that would be great. Otherwise, I may make a motion to move this to committee to put it into 312 instead of 211. I'm happy to hear the discussion before I make that motion. Thank you.
Yeah, I know you're kind of glancing over here. I'm not familiar with I know that we have 312. This is the first time hearing of it as well. So it might be something that you can look into and say, look, this is where it should be. I agree. I don't know if we need to necessarily create an entirely new system. But that's for the board to decide. So I've got member Lear. I know, but you jumped in after we'd already went through the list. So I've got member Lear, member Reel, then member Woods. All right, you got bumped. Yeah.
I'm curious, a couple of things regarding this. I'm unclear. First, member Carey said this would not show letters of reprimand, but disciplinary action implies that it would show letters of reprimand. So I think if we mean suspension, revocation, then I think it should say what will be revealed in this, not just disciplinary action. So I think that needs to be clarified, and I'm not sure which way would be the best way to go. I'm also unclear if this is a new database or if this is an extension somehow of the other current Cactus system that we have. And so that's a question. And then thirdly, if it's a new database, where's the money coming from? How much would it cost? And is there a timeline as to when it would be created, with or without funds? Or I don't think we're just going to find it on growing on trees. So where would the money come from if this is a new database? Or if it's not a new database, and what would that cost? If it's an extension, how much would the extension or the enlargement of the current database cost? So that's a series of questions. I don't know who to ask them to exactly. I don't know if the superintendent would be best, or if Chair Carey has some secret stash of money that he's proposing to use for the database. Anybody who has an idea of where that money would come from. And I want to know, is this supposed to be a new database?
All right, you asked a series of questions. Let's
Maybe start with new.
Well, we'll start
cost.
with Joe first. If it is a new one, then yeah, we'd need to answer that. If it's an existing one, it's still going to cost money. But I didn't catch all the questions, Joe. Good luck to you.
Well, that's why you discuss stuff in committee.
Thank you, Chair. You know, if I understood Board Member Lear correctly, I think 7 clearly articulates that this system would be limited to issues of revocation and suspension. The current system, it would be unaffected by this. This board could decide to keep it, to change it. And the discretion whether a new database has to be built or amendments or changes to the existing one, that's at the discretion of the superintendent and her decision-making process. Nothing in here requires a new or separate system, but the cost is already being borne. And that cost is borne by the fact that right now when someone requests a grammar request or information about information in the UPAC system that they're already entitled to, they're having to pay thousands of dollars to get these grammar requests that they've requested because our system simply cannot spit it out. That our system is so disjointed that our filing system is literally a filing system. Files, paper files, where we're telling the public, well, we'll charge you X amount of dollars of hours to go back and search and pull this information. So there already is a cost, and that cost is to public trust, it's to public transparency. You know, staff put together they called an executive memorandum. I think that's a fancy term, but I just want to know what's happening to our kids in public school. And the trend line is clear. They're leaving. And then I said, well, why are they leaving? Is it just demographics? Is it just this, demographic cliff people talk about? And the answer is no. And I think one of the big factors is this continual erosion of trust, that they just don't feel that they get the information that they need. They feel like there's this opaqueness to where they send their kids for 6, 8, 10 hours. And this system is designed, or the hope is that it allows more transparency into the system. So when we talk about cost, I think we make a mistake if we just look at this as a dollar cost. There's a real cost, and that is parents and students leaving public education. Thank you.
Still didn't get my answer about where the money's going to come from. Okay, I'll let Sarah follow up with that.
All right, Member Reel, you are next.
Thank you, Chair. I think that, I believe in transparency, and I work often in systems and databases and understanding also state resources and the little resources we have to create these really, you can go look up things on private companies that private companies have made, and you're like, wow, why can't we do this for our application or all these different things? And it's like, well, they have tons of money to put into making things a lot more like TurboTax and less like a college application in a USHE system. And so, although this is a great idea, and I think, in my opinion, I think it's not needed, but I wouldn't hate it if it existed. I just think that we spent, hours and hours last year during the legislative session being asked to make cuts. We spent hours at our board retreat talking about what to do when we are faced with a suggestion of other budget cuts. This is not at all on my priority list. This is something that's accessible, it's available, and I would love to see the analytics of how many people even outside of board members go and search on this database. I don't think it's very high. And so I am against this motion because I think it's unnecessary considering all of the big, huge things that we need to tackle as a board and all of the priorities that we need to be spending our dollars on, considering the lack of funding that we're getting. So I'm against this just purely based on resources, dollars, and the necessity. It seems unnecessary at this time. And also, there is a demographic cliff. I research it all the time in higher education. There is a cliff. People are having less babies. There is a reason. There is a change in population. We talk about it all the time. There's going to be a shortage of students going into higher education. There's a shortage of students going into K through 12 because people are having less kids. So that is a fact that is out there. I just wanted to make sure that I cleared that up. Thanks. So, sorry, to finish, Superintendent Hart, I'm not sure what the process would be to create this, because I know during the legislative session we were asked to create a more robust site about our meetings. It was a huge project. We estimated it was like $300,000 to create that site, to just show what we're voting on in our meetings, right? With all of the things we already have and pay for within the systems of uploading videos and clips and all those things, right? So from your perspective, if this passed, what would that process look like to create this site, the dollars that we would need, and the staff that we would need to be able to maintain a site like this?
So I think we have a number of things in play here. One, we already have some information, quite a bit of information, as was noted, available on Cactus, which you can get to usually within 2 clicks. It's not hard. You can Google fairly easily and get to our educator lookup tool. So there's that baseline. However, we also have USIMs in production, and I don't know about putting somebody on the spot. I don't know, Director Feltz, if you would be willing to come on up. I don't know, do you have on the spot encyclopedic knowledge of the educator lookup aspect of USIMS? If you don't, that's fine. I'm scanning the room and you're the best candidate.
Thank you. Jared Felt, USBE IT Director. Yeah, so we're building that into USIMS, and the challenge as far as cost and time is this last legislative session, we have 26 new bills that have to be built into our legacy systems and then rebuilt into USIMS. When we first scoped USIMS, it didn't include all this new stuff. So there's a backlog of items that need to be done. So that we don't currently collect, from my understanding, I came in late, the data that is being requested in Cactus or USIMS. Right. So that would have to be built out.
Okay. So, and I appreciate that answer, and thanks for on the spot. The other piece that I wanted to mention is, as part of the audit that you all instructed internal audit to do, they are creating some databases. So as I sit here and listen to you talk, we have a foundation that already exists, but you are interested in adding items too. We have a UPAC audit that is digitally compiling information happening. We also have USIMS, which it may or, we may have to look at that scope. There might be some issues there. So my point is, we've got a number of things that we could bring together and get it accomplished, so it wouldn't be a ground zero project, but it does have some, coordination that would need to be considered. You know that transparency to me is absolutely critical. This is something that that fits in that scope, but it's not something where, you think of the TV show where the woman twinkled her nose and all of a sudden, Bewitched, and all of a sudden it just appears. It would take some coordination and some time to get what we have currently moved and the water to the end of the row, so to speak. We could, look at it through USIMS. We can use the database that's being created. We can use what we already have, put that together. It would not require a brand new from scratch, but it would require time in order to get there. So that, I don't know if that's helpful or more confusing, but yeah.
Follow up. Yep. Go ahead.
So to clarify, this would be something in the queue of a long list of other items in the queue that we need to build. So, I don't know how that works. I mean, like prioritizing it. So if we put it in the queue, it's something that over things that the state is asking us for. I mean, I worked on that SIS task force, and the list is very long, and it takes a long time, especially when you're working on in-house systems, right? And so I guess then more so the point, if you don't feel like we would need another FTE to manage this or anything like that, then
I'm not prepared to answer the question about FTE. That's a loaded question. My point is exactly that. It may not require as much money as a beginning system, but it is going to require some time and taking into consideration all of those, the legislative mandates versus, and the prioritization. I'm just making the point that I am not Samantha off of Bewitched. Isn't that her name? I'm not Samantha. So we would have to put it into a kind of a project scope.
And we don't collect the data as mentioned before.
Well,
this would be data we would have to add. That's why it would need to be built out.
Well, that's why that audit is so critical, because it may be. That is something that the audit will answer for you. I don't know. The audit is not out yet. So we may have it. That I can't answer for you.
Okay, so my TLDR then would be, this is not something I would prioritize at this time based on all the other work and priorities that we have and the looming systems and data projects that we have.
Vice Chair Wood.
I just want to comment for the public's purposes that if you go to the parent portal, you can click on educator lookup, click on put in a staff or an educator, and it will immediately come up. So it is within 2 clicks off of our parent portal, off of USBE. I put in a name of a person that we went through just in our last executive session last month, and there it says educator has been reprimanded by the Utah State Board of Education. So for that, not everything there, but given that this may be a long process, if this is to pass, the public can do a lot of that already in 2 clicks from our parent portal.
Vice Chair Bollinger.
Thank you, Chair. Yeah, when this discussion item came to law and licensing, we had several drafts to consider. And we talked about how we're in the middle of 2 audits, and so major changes to process, collection of things may be out of context, and there may be recommendations coming from the audit. And I kind of alluded to the fact that it feels like sometimes patching holes in a wall instead of, if we need a whole new foundation, then maybe we need to do that. So I'm not necessarily opposed to considering this. To Vice Chair Wood's point, there is a database that people can currently look up some of this information. In fact, I look it up all the time as in my day job to look at licenses and to see if people are in reprimand. Like, I can get that information so quickly, see what their endorsements are. It's something that is very helpful. But my question would be, if I may, Chair, through you to maybe David Davis, are you working, can you help us understand, like, on a database that you're working on? Because I also hear, I don't want to duplicate efforts or have 3 different databases going on. I want to make sure that we're streamlining things. So can you help us understand, as part of the audit, how this might apply?
Okay, is that on? So Debbie Davis, Chief Audit Executive for the board. So what we are attempting right now, or what I've had staff working on actually for a month or so, is we are building a database. And when I say that, it's a massive spreadsheet. We've identified a number of data points well beyond what this conversation is talking about, but that's so we can analyze those areas that the board has requested for this audit. But it would pick up the items listed here. So probably what would happen, or what could happen, depending on the outcome of what we're able to do, is we put this information together and we're grabbing from a lot of different sources. So as was said, it's not like there's one place currently that we're aware of anyway that you can go and just grab all this information, which is why we're putting this together so we can do the analyses that the board has requested. So maybe the idea is that once we get that put together, and depending on what the outcome of that is and how reliable we think the data is, then that could be something potentially that we could use with our IT group and the policy group and look and say, okay, now that we have this and it's structured in this spreadsheet, it could be something that could maybe be uploaded or interfaced that would give us quite a running start on, hey, we have all these things together. And so maybe we could just, hey, add or look up to what we already have with USIMS or Cactus. That's kind of how I'm seeing it. Did that address your question? Is that?
Yeah, yes, and may I just to follow up? Thank you. That's so very helpful. And I think to your point of you're doing a lot of work to put that together. It may be something that could be turned in and streamlined, and there may be information there that we look at and say, oh, we would want to add that too to a public domain. And so for me, this motion right now feels premature. I would prefer to wait until we have our audits done so we can have a big picture of the things that need to change and the major things that change with UPAC, instead of having unintended consequences potentially of already overburdening the things that are happening in the agency with all of the changes. So thank you for that feedback. And I would speak against this motion at this time.
The screen says we're ready to vote. Boy, I kind of like that. We've got a couple more lights. We'll keep going. I've got Member Earl. Go ahead.
Do you want me to vote first, or just kidding? I guess because I had someone help me. Are there 2 different files? Is the lookup item what you're referencing, or is there a different way to look up an educator? In other words, is the educator lookup that is I'm trying to understand if we already have two systems out there, or if we have one system that the other one draws from. Can someone answer that? Yeah, does the cactus? Okay. Okay, I just wanted to make sure I was talking. Okay, because we're using two different things, and I want to make sure. Because I had an educator contact me this spring because there was a discipline item on his. Anyways, what I'm saying is, I guess I'm not looking at this as that complicated. I'm not sure. To me, most of this is already done. I mean, we'd have to start adding as we went. I don't know if we put a time frame on this by summer of next year or something. I just don't see that this, even the brief description, when we look at our backup for these disciplinary things, it gives 3 sentences that highlights, this isn't complicated. We don't have to go back through and read files. So I can understand us stretching it out if there's not going to be staffing right now, but I actually agree with this because it's enough context. Without enough context, people sometimes are not sure, is that just a flag on the file? What happened? You know what I mean? Then they have to go through the process of a grandma. Then they have to go through the process of this. I just know at the educator that contacted me, they were looking for a job outside of the state. That person didn't want a grandma stuff. They just were like, oh, they just looked at the flag, didn't look at the, the rest of it or the coloring. It was, discipline, and didn't even do a dive into it. And so it prohibited even a movement forward. So I think there is some benefits. I just don't look at it as that much of a hindrance. I think there may be a cost piece, and I would say we would maybe want to maybe it's a date thing that we're working on this over the next year and a half or something. I don't know. That's my opinion.
Member Davis?
I have a more substantive issue, but a quick question. What does if applicable means? Why would it, would the name of the school? But it would still be a teacher out of school.
No, but the incident may not have happened.
The incident didn't occur in school.
I just think that can get confusing, but I would like to amend the amendment that we take off E, and if I get a second, I'd like to speak to the motion.
Sorry, what's your amendment to strike E?
To strike E.
Okay, there's a motion to amend where you would remove E. Is there a second?
Second.
There's a second. Go ahead. Back to you.
If you look it up currently, you can look up the name of the educator, and then it says what the disciplinary action was for the educator, and if it was a revocation or suspension or reprimand. And then it says for additional information, you can click on this to request these grandma records. And while that could incur some cost to the person who's looking it up, it's a holistic view of the situation where both sides represent themselves. And that seems to be much safer for parents, because when we just put a few sentence summary, we may underestimate the real extent of what was going on. And on the flip side, fairer to the educator, because we may overestimate what was going on. And the way it is currently, they can click on receiving additional information and get all of that information from both sides and get a holistic look of what the real situation was going on. I say real loosely because I think we make some mistakes. And that also concerns me of putting a descriptor on there. But those who really, gosh, I'm considering putting my child in this class. I want to know more. I am willing to, pay a little bit of money to get a holistic assessment instead of just a few lines that may underestimate the safety concern or overestimate the accusation. What money?
The money to improve the system we have.
Well, I'm saying we should I'm just saying we should not put a description. It's already in the system. There's already a link in the system right now. If you look it up, they can click on to get any of those records. No, they can get E. They can it says for additional information through Grandma, you can get that, which to me feels like a better representation than a very short summary on both sides of the scale.
To the motion, yeah. I've got, first off, the motion to amend is to strike E. I've got Bogus, Green, and Carey, but those were to the other motion, so I'm looking for those speaking to this motion. Member Carey, go ahead.
Thank you, Chair. Yeah, Board Member Davis, I mean, is really over target. This was a tough one because with that 1 or 2 sentence summary, you don't want to jade the viewer in reading that summary and making all sorts of conclusions from it. But as I looked at what the lawyers do, what the doctors do, what the accountants do, what the plumbers do, they all provide that summary. The board actually goes above and beyond by including that link that says, if you want additional information, click here. And my concern is that I'm not necessarily opposed to that, but I don't think it's necessary because you could have both. You could have the 1 or 2 sentence summary and the click here. But I do think it's important for people that they're able to see what took place, read that 1 or 2 sentence summary, and if they want additional information from there, click the button, make the request. One thing we are finding out, or that I've heard repeatedly, is that the number of grammar requests that we are receiving as an agency continues to grow, and that we are continuing. You want to talk about a staffing issue, no matter how many people we throw at it, the number keeps going up. And so I look at that almost like a courtesy that we provide, and I'm glad we do, that it says click here. And like I said, doctors don't do it, lawyers don't do it, the accountants don't do it, the plumbers, they may do it, but we make it easy because we have that button. And I'm not saying take that away, but by providing that summary, you may answer questions where they're like, you know what, I don't have to go further. Like, this satisfies my search. And we're actually then saving staff time. We're saving that effort. So, but I'm not saying remove that button, but rather I think this will help ameliorate some of the number of grammar requests that we're receiving as an agency. But I think your concern is a legitimate one, that people read that summary and walk away thinking, I know everything I need to know about this. Thank you, Chair.
Thank you. Board members, as you know, when something is mentioned, it gets discussed on the side sometimes. And one of the things that was mentioned earlier was the R277-312. And I'd like, if we could, we've got staff ready to pull up 312 where this probably belongs. Is this? And if it doesn't, if we need a completely new system, then that's up for discussion. But is this it right here, USIMS? Scroll down to 7 if we could. Section 7, what are you looking at? Yeah, section 7, titled Licensing Records. Okay. All the way to the bottom, I'm hearing. Subsection 5, right there. 6. Yeah, I know. I'm getting from Leanne, and you're getting from me, and then, yeah. So you're saying, and let's see 6 in its entirety, please. The superintendent shall provide an online licensing database where the general public may access the information classified as public in subsection 5. What I'm suggesting here, Member Carey, is instead of we're arguing over this in 211. And we don't think that it should be in 211. It's already in 312. And there's some people saying, hey, let's send this back to committee. And some people saying, no, let's take care of it here. And now some people saying, look, it doesn't belong here. We shouldn't, this is out of order, whether it is or whether it's not. I do think that this 312 should be brought back with 3 or more board members. It sounds like there's a handful of us who would say, yeah, let's address this, but let's address it here. put 312 on a committee and look over those issues here. I'm going to look to Member Carey, as he's the one who made the motion, and I'm the one trying to pull it right now. But go ahead, Member Carey.
Chair, thank you. And this is something that staff raised with me, this 312 issue. And I read 312 exactly as number 6 says. The superintendent shall provide an online licensing database. And she has, and we have it. This is not an online licensing database. This is a disciplinary database like other professions have. When you look at the rule 211, 211 specifically says final disciplinary actions. So this is not, which one of these is not like the other. 312 addresses a licensing database. And what we've tried to do is we have tried to, I was going to use it almost slipped out, the B word, but not that B word, the other B word, we're trying to say we have this licensing database, let's make it a disciplinary database. That's what we've limped along with. Really what we need is, just like the other professions, a disciplinary database. Will it draw from the licensing database? Absolutely, because as someone said, about 90% of the information in the disciplinary database is in the licensing database. Some things aren't. It's not searchable by LEA. It's not searchable by school. So yeah, if I want to know this teacher, did they commit an offense, I can look them up by name. But if I want to see this school or this LEA, I can't do it. So that's why I think this disciplinary database is different and it's apart.
So yeah, that answers that question. It is a separate database. Appreciate that. And I want to remember that recall that 211 is titled Utah Professional Practices Advisory Commission Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions. I just want to make sure I'm not trying to skirt around this. I want to make sure we do this right, because what's going to happen is we're going to have a lot of UPAC stuff come before us, and then inevitably we're going to have the AAGs look at this and say, and our policy team, and say, we need to clean this up so we don't have rules and wording in different places that shouldn't belong there. So I'm just trying to tackle this. Now we can continue on with this discussion in 211. I'd love to get it in the right place. And that's all. I guess that's all I'm looking at here is, does this belong here? So Joe, go ahead. Back to you. I know you and I are having a back and forth here. Apologize.
Yeah, no, and that's fine. And Chair, look, if the chair has concerns, I am happy to. And I don't know procedurally how to do this, but I'm happy to send rule. Is it 312? 312. I'm happy to send or support the motion to send 312 and this matter to remand it to law and licensing in the month of September. I'm happy to entertain that. My fear is that if we let this go, this pops up in, the year 2037. So I think that if we can start getting accountability for these LEAs, these schools, and allowing people to see, because we focus on the conduct of the teacher, and I think that's important, but for them to shoulder the weight, which a lot of times I think you can put on administration just for bad training and bad systems. You'll bring that transparency to light with this system, and that's why I think it's important. So, again, if you're suggesting, hey, we're going to let this go, and then you just have to get 3 board members, but my preference would be to have a motion to remand this back to law and licensing in September with 312 for that discussion. Thank you.
Let me just ask it, because again, I'm not trying to kick this just for the sake of kicking it, because the work has to be done. I'm going to ask Ben, I'm looking at you, and I could be wrong and asking the wrong staff member, but Molly's. No, you're fine. Keep talking. I'll just. No. I just want to make sure that Ben's the right person to say, is 312, if we're looking at a separate database, is 312 still the right place to do it, or do we need to find the right place?
I would put this in 312.
That's where you'd put it. What is the title of 312? I guess I should.
Online licensure, I believe.
Online. Educator licensure.
Educator licensure, yeah.
And that fits appropriately in there. I do think it needs to be in the correct place. I do think it needs to have, we're going to have a lot of discussion. We have lights that are still happening. I don't have a light. I do have a light on, but I've got some questions as well. But I just want to make sure that this gets done properly. That if we're going to say, okay, this is going to be a cost, and honestly, if this is the right thing to do, sometimes that's what it costs, right? That's not my issue, is we're not going to do it because it's the right thing to do, but it costs money. No, that's not the issue. For me, it's let's make sure that we do this correctly so that it saves time and energy and it gets done right as we go forward with this. So I think I can interrupt with a motion to postpone or a motion. How does that work? Because we're changing this to a.
There's a motion in backup. Cindy's motion.
Well, I know I need to put this in 312. Did you have a motion? We need to put this.
You can name it Member Hymas's motion.
Well, that would be the motion. And again, I don't want anybody to say, oh, Matt's trying to dodge this. I'm really not. But I do want to do this right. So the motion would be that the above motion, it wouldn't be the rule, right? It would just be this motion.
Which member Carey put forward
Okay.
would be coupled with 312 and be sent to law and licensing as soon as possible.
Law and licensing will be meeting tonight.
No, don't please. I would like to bring it back in September if we could. I know as soon as possible, but I don't want to. When we do talk about money, I do not want to spend money on another meeting in between meetings. Yeah.
Can I ask a question related to Member Davis's motion before you substitute it?
Okay, hold on a second. I've kind of taken some liberties here. You have a question to Member Davis's motion, which I'm about to get rid of.
Yeah, before you substitute.
So what's the relevance of the question? Could you just walk over and ask Member Davis? I don't want to be rude here, but I'm trying to move us along here.
Staff question.
Yeah. So go ahead, Vice Chair Wood.
This is related to Member Davis's motion before Member Hymas gets rid of it. I'm wondering, can staff report to me how much it costs for a single grandma report for a single educator?
Okay. Ben, go ahead.
Ben Rasmussen, USBE Records Officer. The answer is nothing for a single grandma file.
Okay. I'm going to put a motion before the board. I move that the language in the motion above, and for clarity, I move that the language in Member Carey's motion, most recent motion, be sent to Law and Licensing Committee to be considered with a revision of R277-312 in September committee. There's a second. I'm not going to speak to it. I think we know where this is going because I spoke to it long before I made the motion. So I've got Member Bogus and Member Davis to this motion.
That was my motion. I support the motion.
Okay, Member Davis to this motion.
Yes, I support this motion, and I'd like to ask the committee when they go back to work, if they do want to move forward with the summary of reason why the person was suspended or revoked. I'm wondering if the committee could work on a list of like 10 categorical areas. Just looking up some of these, for example, I looked up IHC and one violation was pharmacy violation. We looked up a plumber and it was unlicensed practice. We looked up someone else, I can't remember what that guy did, and it's a falsification of application. So it was like, there's this list of categories. And so, when as a parent, you could say alcohol related, drug related, domestic violence, student interaction, grooming, however you want to make the categories, but it takes out the subjectivity of writing a summary. out of it so that we don't risk this real underestimation or overestimation. The parent can say, okay, that's a category. I want to grandma because it's worth it to me, or I don't.
We can't be sued by inaccuracies as well, right?
Well,
And the
it
longer
just-
it is, the
I really worry for both the people looking and the people being looked at with the summary.
okay. The motion is before us, and that's that the language in Member Carey's motion above be sent to the Law and Licensing Committee to be considered with the revision of R277-312 in September. Let's go ahead and vote. That passes unanimously. This brings us to an underlying motion which is before us, and that is that the board approve R277-211, Utah Professional Practices Advisory Commission Rules of Procedure, Notification to Educators, Complaints, and Final Disciplinary Actions, Draft 1 as amended on second and final reading. Let's go ahead and vote. That passes unanimously. Okay. We just lost a board member saying we needed a 3-minute break, so she's not waiting either. Yeah, she's gone. Let's take a 3-minute break, if we could. Let's go ahead and get back at it here. We just finished agenda item 7.9 on law and licensing report out. And so we are now turning time back over to Chair Carey.
Thank you, Chair. Item 7.10, there was no action for the board, so item 7.11, nope, we just did that, so let's not do that again. This is item 7.12, sensitive materials timeline update. And just for the board, this is this matter originated in our Standards and Assessment Committee. Procedurally, in order for it to hit this board meeting, this particular aspect was sent to Law and Licensing, which we addressed to make sure that it was here in our August board meeting. So the motion for the board with that background is that the board, that the board adopt the 2026 timeline policy draft 1 on the second and final reading and appropriate $60,000 from board discretionary funds for implementation. Thank you, Chair.
Okay, so the motion that came from committee and is before us now is that the board adopt the 2026 timeline policy draft 1 on second and final reading and appropriate $60,000 from board discretionary funds for implementation. Vice Chair Bollinger.
Thank you, Chair. We did have a great discussion about this and appreciate Member Green for attending our committee meeting to help us understand the purpose of this. And I do support this idea. My only concern I have, or one of the concerns I have, is the timeline currently on the actual monitoring timeline. So if you scroll down to the bottom on the summary table, it has phase 1 as starting June 8th and ending August 3rd. And today is August 6th. So my question is, if we pass this draft as is staff still going to be held accountable for doing all of these steps and being done by December, or does this or is there flexibility or pushing this back? I'm really just concerned about maybe we're setting staff up for something that is not reasonable. So I don't know if a staff member can help us understand the timeline. Is it more of the actual 26-week timeline that we need, or is it the deadline?
All right, welcome back, Davina.
Thank you. Davina Southoff, Library Media Specialist, Teaching and Learning. The timeline would need to be adjusted, just given that we discussed this originally in June, and so we don't have that portion that should have been done by August 3rd is not completed, and so we would need to move it forward from this date.
So we would need to just amend so that everything would shift. Is that what I'm understanding?
Correct.
This is the committee's baby. I guess I need an amendment.
So yes, I'll make an amendment. And if somebody that's brilliant, Elise, that's helping type this up, to push the timeline, the calendar window back, starting today, or Monday.
What's that? Okay, so the motion to amend is that the timeline be adjusted proportionately with Monday, August 8th, 2026 start date. That was a motion that Vice Chair Bollinger made. It's been seconded. Is that right? Member Kelly, was that you? Okay. Back to you to speak to that.
Yeah, thank you. I just want to make sure that we provide ample time for our staff to actually follow the proposal. It's I mean, a lot of time and energy was spent in figuring out each of these phases, and so I just want to make sure that you have the time that you need to do this correctly. So, if we're going to invest $60,000, I want to make sure we can do it right. Thank you.
Member Reel.
Thank you, Chair. I have a question about just the, sensitive materials is like one of the areas of our schools that is the most regulated. There are lots of rules, there are lots of laws, there are lots of things that that we, and for a good reason. But I can, after going through the library policy, a lot of the concerns that I got from the librarians were just like the amount of work that a lot of these things take. And I always think of the red tape as that's time they're not spending with our students, helping them learn. And so I'm trying to understand if this is going to be, I know that this is more focused on vendors, and I know that our librarians do a great job of making sure that, they vet the vendors, and I have issues with vendors all the time, but I know that in this area there is that. And so I'm just wondering if we foresee any sort of burden or extra time and energy that will be needed to be placed on our librarians with all the other regulations we already have within the library and sensitive materials. I read it, but I just and we discussed it in committee in standards originally. I'm just wondering if we have if we see this being more of a large task than what it seems easy, but I'm worried about the time and energy it's going to take from our librarians. So I'm not sure if you have any information on that, or if you have any perspective on the burden of the librarians or the LEAs.
So yes, this is going to take a significant amount of time. And one of the things I was thinking about as I created the timeline was to, limit the amount of time that the librarian themselves would have to participate in the survey, and hoping that a lot of this could come from the district themselves. Procurement goes to the district, and they'll probably have more of those records than the librarian would, but there will be impact on both the librarian and the LEA, particularly because, or the district at the district level, particularly because we do not have a district librarian in every district who can navigate these questions, where like in Canyons, they have a district person. And so, she can take that time to answer as many questions as she can without having to have the librarian do that. So.
Okay, thank you. Yeah, having been in audit, I hear about, when we start audits, oftentimes there are some LEAs that just don't have the resources to pull all the information that they need for the audit. Whereas some, like Davis, it's like, oh, we have 5 people that can do that. So that was sort of my concern. Okay, thank you.
Okay, I've got, again, the motion here is, we're talking about the timeline. So I know Sarah was off base here. Okay, okay. Timeline? Okay, and Member Green, timeline? Question on the timeline, or is yours on the overall motion? To the timeline? Timeline.
You probably want to attach it to the draft.
Okay. So the motion then is that the timeline be adjusted proportionately with a Monday, August 10th, 2026 start date. Let's go ahead and vote. Okay, that passes unanimously, which brings us back to our underlying motion about the timeline policy, right? As amended, draft 1 as amended. So Member Green, go ahead.
I would just like to amend I'd like to amend to include the USBE library review addendum revised, draft 1.
So the motion is to include the library materials. Sorry, what did you call it?
It's in backup there.
I've got the title.
USBE library review addendum revised, Member Green, draft 1. It's the last document listed. There's a memorandum, and then there's also the USBE library review, and I want to add the USBE library review.
So you want to, okay, so the motion is to include the USBE library review addendum revised, Member Green, draft 1, to this
the school library
timeline.
Yeah, monitoring
Okay.
timeline. And I'll speak to it with a second.
All right. And there's a second to that. Go ahead and speak to that.
Okay, yeah. So I just I've followed this for a really long time. I've already said a lot of words. I've already spoken in, standards and assessment. Thank you, Law and Licensing, for allowing me to come. Maybe this is more towards Finance Committee. But I've just been, compiling a lot of information. I'm viewing this review through the industry lens, not through like the educational realm, but this is more on the front line. And so, and I just have I'm just going to read it briefly. It's just a little tiny paragraph, but I think it sums it up so I can get right to the point. We can move on. It's the memorandum there. It's the second paragraph. It just states that this instrument, this survey, it's just meant to do 3 things that the outline does not yet fully do. So the first is that it just translates the review's objectives into the industry's own working terms. I've said there's the edu speak of this, and there's kind of like the industry speak. There's the business language. My goal is like, it keeps veering off into the educational realm, but we need to keep it in this other realm, which is why I've put in a lot of effort getting these specific questions. So it's to help kind of steer that. So I'm just going to read that again. First, it translates the review's objectives into the industry's own working terms. Approval plans, standing orders, opening day collections, shelf-ready processing, cooperative contracts, curated selection lists, and so forth, so that questions match how the acquisitions actually occur and cannot be answered around. The second is that it follows the money in both directions. So what LEAs spend and from which funds, and what flows between LEAs, vendors, and professional organizations in the form of dues, conference travel, incentives, grants, and donated materials. And then the third, it pairs nearly every question with verifiable record, so purchase orders, contracts, vendor manifests, training logs, so forth, so that the findings rest on documents rather than just recollection. So the questions, I've just posed them as just deliberately neutral, factual, grounded in Utah's content standards, and just simply asking what is bought, from whom, under what terms, with whose money, using which lists, and then checked by the steps that are in place. So I do want to just highlight also that the attached instrument, the survey, it is offered to strengthen the data collection. It's drafted for staff refinement and board discussion, and it's not as the final form. So hopefully it's just kind of like that nice kind of focus supplement. Thank you.
Yeah, Member Lear?
I'm going to ask a really simple question that maybe should have been obvious, but I can't figure out, Emily, who's going to do this work in 160 LEAs? Who is assigned? Is it not every LEA has a librarian? We've established that. So,
Not every district.
and not every district or not every LEA has a librarian. So I'm just trying to figure out who would have this business information and be able to complete this survey that who were you anticipating would be that person?
Member Green, go ahead.
This is part of, I think, what we're working with. Davina, may I use your name and reference as we've been building this out on who the who is. Librarians obviously have their part in procurement of library materials, but there are quality checks that are built into that. There's, people that have to approve that at the district level, if I'm understanding this correctly. There's contracts that are approved. There's the financial part that's approved. So there actually is, there are processes in place where people go through their lines of authority. And so there are people, if a school has a library, then these processes have already been utilized. How and who, I think I might refer to Davina for that answer, and maybe the work that she's been developing in how we're accessing LEAs that fit the guidelines.
And can I just clarify what I'm asking a little bit, Davina? Maybe it seems really clear to you, but I'm concerned that there are multiple people who are now, and some LEAs are going to have multiple people who need to fill out this survey or participate in filling out the survey. Some LEAs are not going to have any information at all. Maybe they'll claim they have no library materials. I don't know how it will go. But, I mean, help me with a vision of how an LEA would fill out this information. I'm kind of, maybe I'm not enough of a business person.
Thank you. So the first thing I'll say is that we aren't going to be, well, at least in the timeline that I've proposed to the committee, we would not be sampling all of the districts for everything. So it would be a random sample of certain districts for certain items. So like phase 2, the supply chain and procurement would be 12 districts and 3 charters. But then when we get down to regulatory compliance and training, that would be all 41 districts and charters, depending on the information that we're looking for. Maybe every district responding to something, and it may not be. The other thing I would add is that, and forgive me, I haven't had a chance to go through Board Member Green's survey document in good detail, but the way that the timeline is set up is there's 3 different phases, and I anticipate that being broken down so it's possible that a different person is responding to 3 different phases differently, but it might be in a district that one person is responding to all 3 phase questions. Does that make sense? So I had it broken down like phase 1 questions, phase 2 questions, phase 3 questions, so they could go to the right individual, and it might be the same person and it might not be the same person.
And then one follow-up, if that's okay, Chair. To Davina, is that okay? To what end? I mean, what is it we're going to find out that's going to be valuable?
If I may, I think that is probably a question for this. I put together at the request of Board Member Green and the committee. So,
and Emily, then if it's to you, then help me in maybe in layman's, not so much heavy business terms. What is it that we want to accomplish by gathering this pretty detailed survey information? What is it we're trying to accomplish?
It's a great question. So the state of Utah, we've been through, a few years here of working through the sensitive materials law. We've developed the rule, and now we have a year or two of data underneath our belt. And what we're seeing, the way I've phrased it, I'll phrase it again, is we've been able to put a Band-Aid on a hemorrhage on as far as, the type of novels and materials, pornographic novels that have made it through. Salt Lake Tribune had an article in a way posing that it was, these parents are the ones that are doing it. And we have this legitimate argument that we want to protect our librarians. We want to protect children. And we want parents to know that they have access to quality literature. So all of these are very relevant arguments and concerns. This Band-Aid on the hemorrhage analogy that I make highlights, and the fact that we've had a year using this rule highlights that there are still issues that exist on the front line. So we've been able to address kind of the tail end of this. We're highlighting that there are issues that still exist industry at large. And I think that my biggest fear is that we will continue to have legislation go through addressing things that we don't understand. And right now, I've asked these industry level questions. I have yet to be able to have a conversation with people that can answer that. Now we know that there are trainings that take place, organizations sponsor, they offer trainings, they do, again, in layman's terms, there is an industry that engages with public education. Their product is selling curriculums, novels, literature to supply our public education. And so I believe that it is very important that we understand that and that we don't keep setting up our librarians to fail, and we don't keep allowing an industry to have unfettered access to be supplying a product that goes against state law at this point, federal law. And it really is highlighting something that exists and that has become a problem. And the only way that you can work better towards that is understanding it and understanding the frontline industry partnerships, using the business language, the contracts and the funding avenues and the marketing I see it being very, very helpful. And I'd like to also highlight that I really do, we want them to be the professionals until we have a review and then we demote them, and we don't want them to be the professionals because they don't know. They either are or they aren't. Now, if we decide that there is a gap and maybe they don't know this, the review itself will actually highlight ways that we can fortify that. We can build out trainings. We can say, hey, there actually is, it's just time. It's just time to have the conversation. We can build out those trainings from the USBE, and then everybody's in just a much better place. And so, there's a handful of reasons for this, and I've highlighted, I hope I've remembered the most important.
Thanks. I guess I'm still a little unclear. Do I hear you saying you think that vendors are intentionally selling pornographic materials to schools? Is that what I think? Is that what you're saying?
You know, if we wanted to spin it politically, you could say, yeah, we're putting our stake in the ground, and yes, that's happening. What we want to understand is how vendors have access to public education. And we don't understand that relationship. Yes. I will highlight one thing though. In Utah, a new school opened and the vendors have a pre-curated list. It's the starter library, 10,000 books or something. You just push, hey, order your starter kit. Those books come. When queried about how many books referenced American heritage, I'm like, oh, that's great. They go to the search, and there wasn't a book there about American heritage. And what I realized at that point, this actually extends beyond, let's say, sensitive materials. It extends beyond pornographic novels. It, extends beyond authors that work with publishers, that work with vendors and distribution avenues that are pushed and formulated through, curation, the ALA itself and other organizations. They actually move outside of just distributing books. They offer a slew of industry products per se and services that we utilize through the state education system. And I think it's time we understand what that actually looked like and what influence it has. Is there industry capture with some of the organizations or some of the agendas on the books? We don't know, but I'd like to find out. Let's say classical education vendors and distributors don't have fair access because they don't have the funding mechanisms or the access to public education because maybe there is a conspiracy there. We don't know. I would love to see the comparison, side-by-side comparison. I've been very thoughtful in already listing those, and in doing so, I hoped that it would help staff. It would be a compliment, to just a launch pad, again, to assist and highlight again what it is that we're looking for. So if you look at that document, you can see I listed those out, what some of those supply chains are. And then we'll get an idea. If there's something missing and we can fortify that, that's what we're just trying to find out.
Thank you.
I'm just going to jump in real quick because we spent a lot of hours in Midway discussing this, and I think the work that has been done is fantastic, but I am going to speak against this motion just because I just trained on this a few weeks ago, right, of the how will versus how well scenario. And this is so prescriptive. This is what you're going to do, staff, and this is how you're going to do it, rather than us saying, here's the timeline, here's what we want you to monitor, go do it and report back. And so I think we're stepping out of our lane and into we're doing staff's job. We're telling them exactly how to do it, if you will. So that's where my concern is. But that's just me. Again, here we are as a board. It's before the board, but that's my thoughts on this. I don't want to be. I contradict myself all the time, but I'll try to minimize it a little bit. But anyway, here's what I've got as far as comments on this motion. And remember, the motion is not the underlying or the overarching motion. This is the motion to include the USBE library review addendum revised, member Green 1 or draft 1, as part of the 2026 timeline policy. So I've got member Bogus, member Davis, and then back to member Green. Oh, sorry, where were you at? You were after Bogus? Member Bogus, Vice Chair Bollinger, member Davis, member Green. Go ahead, member Bogus.
Thank you. I actually really appreciate this document. I like that it provides clarity. I like that it takes us out of edu speak and into business speak so we can track these pathways. And I heard a member, and I don't recall who, so I genuinely don't recall who said it, that LEAs might not be able to answer their questions. And I think therein lies a problem. If we have an LEA that doesn't know the answers to these questions, we have a far bigger issue than we ever thought we had before. We should be utterly shocked and horrified that they can't answer these questions. And so I would argue that if they can't answer them, that tells us a bigger part of the story than maybe answering the questions might. But the fact that they don't know how these books get in their school is very concerning. And so I would just speak in favor of the motion. I like that it's a guide. I like that Member Green said this is a great thing to just hand to staff and let them work with it and expand it. I think that it does a really great job of articulating a manner in which it could be understood by the board as it comes back, so that it's not just a pile of papers. It's something that we can understand and make decisions from. And so I really appreciate that. And I think you've done really good work. Thank you, Member Green.
Member Davis. Hold on. There you go.
Thank you. I can support this if my understanding is accurate. I'm checking it with our other committee chair over here, and she thinks that it is, but I want to make sure. But so what I'm understanding is that our staff is going to send this opportunity out to all of the librarians, all the LEAs, and then with this money that they can get to compensate them for the time that they're going to take to do this. And they may, if they feel like they have the bandwidth and they want to get the extra funds, they can do this and pick it up and do it, after school or on their own hours and get this compensation to do it. And it will be on a voluntary basis. It's not like anyone's going to be forced to do anything. And if they are, then it probably should be an audit, not something else. But am I understanding it right? Everyone's going to be notified. Those that have the bandwidth and want the compensation can do it. Is that right?
Yes, that is correct. It is voluntary, as you mentioned. And the other thing that I would add, or maybe as a question, if the board adopts this library review addendum revised, I would want clarification that are those the only questions, or should there be other questions, or can the document be revised or included in other questions? I guess I would probably want to have more direction as far as that adoption of this addendum.
Yeah, Member Green, go ahead.
Okay. So great questions. And I myself wasn't sure how we are going to access the LEDs. I know that it's in the process, right, of development. So kind of like the 250th, it took a second to kind of find our way, and we did, and it worked out great. It was a lot of work, and I recognize that, and I appreciate it. I made it a point to include my memo on there, just to, in writing, highlight that it is drafted for staff refinement and board discussion. There's committee, but now we're in the board. Board discussion, not as a final form. And I know that they've already been working hard at finding, creating questions. There's two things here. I knew that I would be presented with the argument that I'm doing staff's job. If I didn't do this, though, and I went directly to staff, I would be accused of subverting the board and going straight to straight. So I decided I liked this way better because it's on the public record. So we're here. And I liked the fact that my point is made clear, that every time I've had this conversation for over 3.5 years now, it always goes back to just, hey, librarians, do you order books? Yep. How many? Okay. Did you pay for them? Great. Are they on the shelves? Perfect. That's not what we want. So I had to physically put it in writing so that the direction and the intention was 100% clear, because it gets really confusing. It just does. And, the arguments do they know this? Again, if we don't, we're highlighting an area that we can get better in and, make our libraries better. For me, it's just a win-win-win all the way around. But we are lacking an understanding of the front end of library procurement and library material procurement, the industry relationships that exist, and we can find that out. So with that, this document would be a guide, a reference point. Davina's going to take her amazing team. We're going to like iron out these questions and make sure we're not duplicative. We're going to make sure that it's staying at the front end type questions. And then we're going to build out from that. And I look, there's a lot of work there. And I don't need to pat myself on the back, but I definitely am not trying to subvert anything. I'm staying above board and being very, very clear what we're trying to get at. And that's to help everybody.
Vice Chair Bollinger.
Thank you, Chair. If I may, through you, Chair, to ask Davina a question, then I would like to reserve the right to make a motion. Davina, looking at this amendment, or addendum, excuse me, the addendum, we just talked about the timeline piece and the concerns about such a tight timeline. And I know you said that you didn't quite get a chance, you got this kind of a last minute. So with this information that's on here, would you need to amend the timeline to meet all of the requirements on this document?
The addendum and the timeline do not, there's some overlap, but there are differences between the two. And so depending on the motion that the board makes, we would need to make sure that what's in the timeline and or the addendum are aligned and or inclusive of everything that the board would like to do.
Okay. Thank you. So with that, I'd like to make an amendment to the amendment. And
yes, I know we are, it is, but we are just going to, if we keep having like a response every time, we're going to be here a lot longer. But,
I appreciate this. I'll make it quick. My understanding is that we are currently still developing the survey. So what we've created at this point is not completely done. And so that, if it's not done and we have specific questions, we just kind of go like this. And then we're good to go. So that's what I was hoping.
Okay. So I would like to strike include and change it to consider. And with the second, I'll speak to it.
So there's a motion to strike the word include from the amendment and replace it with the word consider. It's been seconded. Go ahead, Member or Vice Chair Bollinger.
Thank you, Chair. And I know there's been a lot of work into this addendum, and it may be really helpful as you develop it. I really am concerned about that conflict between staying on the timeline or being, prescriptive in the addendum. I agree with Chair Hymas that it does cross the line of the how will versus how well. However, at the same time, I understand what Member Green's talking about, where there's that fine balance of when you put so much time and energy into something and it doesn't come back the way we want, it can be frustrating. And I do believe that clear is kind. So I think that by striking include and replacing with consider, that would then help staff understand this is the scope, understanding what can we fit into that timeline, understanding it is the procurement and those business words and all of that we want to make sure we get the right information to make decisions moving forward. So that's the reason for my amendment.
Member Earl to the amendment. Member Booth to the amendment. Go ahead.
I just have a question. Is there a reason why the timeline has to start today and end at whatever length of time you had set out on the timeline? Or is there some flexibility, as you're mentioning, Vice Chair Bollinger, to take whatever time we need to get the questions right and to synthesize together the efforts of those that have spent a lot of time and are creating this kind of out of the air to make this a very productive and helpful instrument in gathering information. And if it didn't end until whatever later date, once we did decide now we're ready to start, we've had this, I'm just wondering if there's some flexibility with the time so that we get what we're trying to achieve and not feeling like we're a slave to the clock or an amendment that says, okay, starting today, and you have till this much time to get this done. The information will be valuable whether it's 2 weeks later or a month later, in my mind, but I may be missing something.
Member Green?
Said I can answer it. I don't know if I'm correct, but my intention with the timeline, deadlines are always good, but also I was hoping to get some understanding before the new legislative session. I think again it's we have to understand the things that we are engaging with and making law about. And again, I'm going to highlight we put a Band-Aid on a hemorrhage. And in doing so, because we have a year under our belt, being able to, we've proved processes, things are calming down, but then the articles come out of, accusations, oh, these obnoxious parents, they're the ones doing all these things. And it's like, well, it's still highlighting that there is access to this space through the industry. And if we're getting impatient, which is we're seeing, you could say people are exiting public education because it's not stopping and they're done. So we want to bring reputation back. We fix it, but we don't fix it if we don't know what we're dealing with. And you have to understand the front end, or this never ends. The book reviews never end. The headlines for the book bannings never end. Just this whole conversation never. And we continue to lose as public education. And it's got to stop. I'm okay to just take a breath and say, okay, December's not in the cards. And maybe that's okay. Maybe that's the way it's supposed to be. And maybe really that is better. And we should maybe let the timeline flow in the way that it needs to. And I won't be privy to that study, so I'm going to have to bum it off somebody when it comes public. But that's the why, Member Booth.
So the motion before us is to strike include and replace with consider. Let's go ahead and vote. That motion fails. 6 in favor, 9 opposed. Those in favor are Member Lear, Member Reel, Member Hymas, Member Wood, Member Bollinger, and Member Davis. Okay. So the underlying motion then is to include the USBE Library Review Addendum Revised, Member Green, Draft 1, as part of the 2026 Timeline Policy. Member Earl, to this motion? No? Okay. Let's go ahead and vote then. All right, that motion passes. 10 in favor, 5 opposed. Those in opposition are Member Wood, Member Reel, Member Bollinger, Member Lear, and Member Hymas. Now we are on that the board, so I don't know how the motion would look. It's that the board adopt the 2026 Timeline Policy, Draft 1 as amended on second and final reading and appropriate $60,000 from board discretionary funds for implementation, and that the timeline be adjusted, and Yeah, you just don't know where it is exactly, or the and include the USBE Library Review Addendum revised, Member Green Draft 1, as part of the 2026 timeline policy. Member Earl to this motion.
Yeah, just wanted to speak broadly to this. I appreciate the details so we can get information that's usable. But the other thing, and I didn't fully understand this, but in breaking down the timeline, I like that it's a group can, schools can choose the first piece or the second or the third, right? It's not as weighty as you've got to fill out this whole thing and you've got to, so I do like that provision. I feel like it doesn't overburden entities. It provides, and once again, it would be a choice that they would have to engage in this. And I hope people do, and I hope we're able to get some information that's valuable for us. So anyways, I'm just speaking in favor of the motion.
Okay. Vice Chair Bollinger.
Thank you, Chair. So my concern now, I was supportive of the original process and timeline. Now that we've added additional addendum, and Davina spoke to that with that addendum, we won't be able to meet the timeline. Now we've just put our staff in a situation where they are being asked to do the impossible. And I think that's a hard place for our staff to be in. So with that, I would like to make an amendment that the staff have the flexibility to adjust the timeline to meet the requirements.
It was just giving it time to process on the screen there. The motion is that the staff have the flexibility to adjust the timeline to meet the requirements. It's been seconded. Back to you, Vice Chair Bollinger.
Thank you. I want to make sure that if we're going to spend the money again, if we're going to spend $60,000, I don't want us to not be able to meet the requirements. And the board, when we put things up to the board, I support what the board decided. So now that the board's added the addendum, I just want to make sure if we're going to do that, we want to make sure that we have the time to answer all of those questions. So with this amendment, I'm hoping that that's the win-win.
Member Green.
Can I just ask then, and maybe Davina, if I could ask you, do we see this being able to be done in the next year or 6 months? Clarifying, one more thing, that I wanted to highlight that the sections like A, B, C, they complement those phases. So those are built into those little chunks, those phases that occur and in complement to what you've done as well. And if we want to also look at it, every question doesn't take 2 days. It's kind of like your multiple choice test. Sometimes you get stuck on the one, but you go through and you do the quick ones first, and then you put your efforts on the one that you know is going to take. However it is you guys do them. Maybe you do the hard questions first and do the easy ones last, but everyone takes their test their own way. But I wanted to highlight that. It seems cumbersome, but it's organized into each phase. So taking that into consideration.
Yeah. So I think that 6 months would be difficult, given that the team is me, for reference. But I think 1 year would be very, very doable. The other question and maybe guidance I would ask for is that when we say include this review addendum, are we talking about that just the questions are part of the survey, or like what should be included that goes out to the field? And is there any room for example, like one of the questions says used regularly, used occasionally, not used. And some of the other questions that I've already developed have a little bit more precise language as far as how we answer that. So I want to make sure that I'm following the board's direction and that there is some flexibility as far as like designing questions that will be easily able to be answered by, like when we put quantitative numbers to a question, it will be easier for our LEAs to answer that as opposed to like, what does used regularly mean? That might look differently. Someone else might look at that and say, is that 5 times? Is that 10 times? So I would want to be more specific about some of those questions, if that makes sense. So I want to make sure that I am not putting myself in a position where I'm not following what the board's direction is.
That's why, again, back to this, it's just it's for staff refinement and develop that so it makes sense. It's going to be something that you can read the data, receive the data, and what is in front of you now is the questions and the front line questions that are of utmost importance. But please make that fit. And again, I know that there is the beginnings of the survey right now, and I hope that this is a complement to that.
This is tough. I'll say what you're not going to say, Davina. No, you're fine. It's just here we are. We've got Davina over this project. Molly's sitting right here, and we're saying, forget you, Molly. Davina, when can you get this done? How quick can you get it done? Here's the priorities. Right? At what point, guys, do we say, this is not our job? I can't do Molly's job. And I've been getting this pressure and conversations, not only from staff doesn't say anything. Molly dances around it because she's kind. But I get this pressure from legislators all the time. And I'm going to go sit before them again and say, no, we're irrelevant. We're telling the agency exactly what to do. And that's not going to go over well. And so again, the board that's just passed 10-5, 10 of us say, yes, forget this. We're doing this. This is where we're going. Again, I'm exaggerating mentality here, right? You could probably feel some of my frustration as I'm doing what I can, and we are doing what we can as leadership to keep this board on the map, and we're being fought with our own members here. So again, we have an idea. We want to see something done. And here we are saying, Davina, how fast can you get this done? Right? You don't belong to Molly anymore. You belong to us, all 15 of us. That's not fair to her. It's not fair to Molly. It's not fair to any of these other staff members back here. So with that, I'm going to ask Vice Chair Bollinger to chair for me for just a second while I just step away, if that's okay.
All right. It looks like we have Member Booth and then Member Green.
We certainly don't need to tell staff or superintendency how to do their work. But there may be times where we have questions and we feel that we don't have the information and that perhaps the agency doesn't have information that could be helpful, whether it's relating to libraries or whether it's relating to absenteeism or whatever. What would be the process? What would be the preferred process to gathering that kind of information without being perceived as trying to be heavy-handed or assume responsibility for things that are not our responsibility? Because I fully support the superintendency and our staff, but sometimes there are questions, and if it's just not the time to ask the questions, and that has to come at some point later in the big scheme of things, we would be certainly open to that.
Thank you. I'm going to direct that to Superintendent Hart.
So I wrestle with this. You all need the information that, like you said, that you need to make decisions, and you have things that are important to you. It is very difficult to answer to individual board members and I'm speaking overall, not about this particular issue or any one issue. How it's supposed to work is that the agency responds to the board. So the board decides that something is important, and then the agency, I, go back and come up with a plan based on what you say is important, and then we bring it to you, staff brings it to you, and you hammer out the details and say, yes, go forward. What happens is we are in a time where everything is expected overnight. So people are not, in many cases, waiting for the board to speak. And answers are wanted now, and projects need to be done now, and the speed of which a board operates is very different than the speed in which individuals operate. And I don't think that that's fully understood, and I don't think that we have, both the agency and the board, have worked out and talked about what is it's a military term, operational rules, rules of engagement. We haven't really talked about rules of engagement on how to meet the needs of the board. We keep trying to do it the way maybe that it's always been done, but you get frustrated when things take a long time, but you meet once a month. You have full agendas. You spend a lot of time on certain activities, something like, let me give you an example, consent agenda. Consent agenda is designed to be quick. It's designed to be things that are operational. What's the non-controversial, operational, and the rules of what goes on a consent calendar are pre-established. You go through it. There are things you can just check off the list. Well, that's not what our consent calendar has turned into. So we haven't renegotiated those understandings as a board and as an agency so that we can meet your needs in an efficient way. We have 15 members, and honestly, I have 15 boards. I don't have one board. So that's very hard to manage. So then you get bottlenecks, and then you wonder, then it makes it worse. So it's a self-fulfilling prophecy. At some point, we need to have some discussion about how we do our business, our rules of engagement, because for the very reason you're talking about, it comes up in a lot of spaces. And people have talked around the edges of it. They've meeting more often but shorter amount of time, meeting longer amount of time but less often. It's a topic that I constantly talk about with other chiefs. What are you doing about this issue? What are you doing about this issue? And the legislature doesn't help with the number of issues that they have. I think, quite honestly, they have the same problem. The speed of our world is moving at a faster and faster rate. And in fact, I was just having a conversation when Robert's Rules of Order, the book came out in 1876. It was this thin. And the rules of Robert's Rules of Order, the book is now, it's a doorstop. I think that it would be well in our interest, because we do need to reduce that frustrational level. And staff has a hard time keeping up. I have a hard time keeping up as your superintendent, and there's frustration all around. I think that's a very valid question. I don't think there's an easy answer. I do think that we need to think about how we utilize our committees and whether or not that committee structure, while it served a certain purpose, does it still serve the same purpose? How we use our advisory committees, how we engage with ourselves and what we allow and what we don't allow. Those are things that have to be talked about. And the simple fact that you are even busier with individual interests, and then, it's kind of a bottleneck there, means you have even less time to stop and think about your processes. But I do think it's an important conversation. I do think that we can do a lot of things to tinker around the edges, but if you really wanted to solve it, you would really need to start, what is the term again, Scott? Was zero, like where you start from zero and zero-based budgeting? I really think you need to take perhaps that idea, erase the notion of what being a state board member looks like, and think about what you want to accomplish and what resources you have, and thinking about how to get from point A to point B, rather than trying to continue to put Band-Aids on a problem. That's exactly what the legislature is also wrestling with, and they finally just said, here, we'll give you flexibility, you go figure out pieces of it and bring back a solution. I think I would suggest the same things to you all as well, because it is very hard to take the strategic plan and your vision and mission and link the things that we spend our time doing and the things that are talked about in board meeting, and connect them all in a coherence. And I think that you all are feeling that frustration, and I see it growing. So I don't know if that answers your question directly, but it is I have been on the job 1 year, and I continue to learn things about the agency and the board. I am not close to being an expert, but these are the impressions, and these are some of the things that I've come to that really come to the top of my mind right now.
Okay, thank you for answering that question. We do have a motion on the board. Member Green, is this to the motion? Okay, go ahead, Member Green.
Just my response, I know, like there are heavy subjects that just seem to surface on every board meeting. Trigger points. I know that this one already was a trigger point. I want to clarify that my question about the timeline was not to say you got to have it done in a week. It was actually, I just stated 10 minutes earlier that, the December timeline, it's probably not in the cards. And I also said that's probably okay. So I want you to know, it's okay. I get it. The reason that I asked that question, it is, if it's going to take 2 years, I think I want to know if it's going to take 2 years. If it's going to take a year, I want to know. One is a selfish reason, because I'm done in December, technically January 4th, I think. And with that, I just want to know how I need to make a mental note of how to follow it, because I'm extremely interested in this. And that's all for that reason. So I'm open to the timeline requirements. In small business, you got to do quality checks. Your purchasing departments have rotations. They have schedules. You order from China. It takes months. You order your samples in, you review them, you send back the corrections. There are dates. It is a normal industry question to ask for timelines, and there was no ill will with that at all. And so I also just, I guess that's all I have to say. I want to extend that little palm leaf and say, we're doing great. And as far as what it means to be a board member, I'm sitting here looking at my mission statement, and for anybody that's listening in, ours is that of to focus on an academic and organizational excellence in Utah education for an elevated, educated citizenry. Underneath that, we made a thoughtful list of what that means. It protects information systems, manage public education funds, directs transparent operations, develops policy for education, advocates for Utah students, provides support and oversight of schools. Knowing the front end of library procurement and material procurement checks all of those boxes. The only one I didn't read on that was sets academic standards. You could probably make an argument for that. And so what is my time worth? Obviously, because of the effort, this is something I felt that was extremely worth my time as a board member. And it feels really good to be able to bring that forward, and I appreciate the opportunity to do so.
Okay, thank you, Member Green. All right, the motion on the screen is that the staff have flexibility to adjust the timeline to meet the requirements. Seeing no lights, let's cue that up for a vote. Member Lair. Okay, so that motion passes unanimously, 13 in favor with 2 absent. That takes us back to, I believe, the underlying motion. So if we can scroll up to the underlying motion, whoever's driving, and make sure we get that wording to add the flexibility. As I believe Greg's adding that in, one of the things Deputy Newey or Superintendent Newey pointed out to me that the way that this is worded is a timeline policy where it's not a policy. It would be a plan. So with that, is there any objection to changing policy to a plan? Okay, so we'll consider that unanimous. AAG Cooper.
We just, in discussing it back here, and how you have all your other little conversations going on, we think it probably needs to be clarified that what is being approved in the motion is that the staff is able to work on this, that this is the springboard for where it's starting, because that's what I understood Member Green to say, is that this wasn't final by any means, that she was just proposing this so they had some place to start, but we think it needs to be clarified that this is not, these are not the surveys that are going out. This is just where they're starting. Is that correct?
Yep. Member Green, can you tell me the wording that's on the bottom of the document that you said that is in the document?
Separate item in backup, and it's the memorandum, I believe.
So do you expect them to create the survey and bring it back, or are you expecting them to administer the survey?
I would expect you to administer the survey. Is that right? Sorry.
Is that the question you're asking? Administration versus creation?
From what you were saying, that you started a framework of a survey, but you understood that staff may have changes and board may have changes. So this was the framework. This was not the finished survey. Is that incorrect?
That is correct, yeah.
Okay, then I think that we need to make sure that it's clear in the motion that that's where we're at, that this is not the final thing going out.
So AAG Cooper, would that be in our actual motion where it says the flexibility for the timeline, you would say that flexibility for the timeline and what would be the wording that we would want to add then? And the process or in the,
That the instrument would be a starting point.
and that the instrument would be a starting point?
Correct. Subject to board approval.
Okay. Let's go to Vice Chair Wood and then we have Member Booth.
I just have a question to that because we voted to consider it and that failed 6-9 that we were going to include it. And then your words were, well, this is a starting point to move forward. So that's using this as a consideration. How does it all work together? Because to me, consider went, we're going to use this as a baseline, we'll move it forward and create it as in a way that will work. That failed miserably. So what this board voted on was we will include this. This is it. So how do those two mesh?
Member Green.
I have curated specific questions that I feel are the most relevant to finding out how the front end of library curation operates. I would like for as many of these to be used, but I know you have already begun your survey. If they can complement your survey, if they can help clarify in any way the direction that's already been developed, then please use that accordingly. Outside of being on the phone with you all the time, I only felt that this was the most specific way I could communicate what it is that we're looking for in the review. And that's all I have to say. And I've got the memo there. I feel like I'm
So I think part of the concern is that the memo is not
missing.
included with the motion, and I think that that's what AAG Cooper is mentioning, is so we either need to include the memo so it's the wording is, or we need to add in the motion that the flexibility is there, is what I'm understanding. Is that correct interpretation?
Or as was pointed out, when it was talked about just as being the flexibility and the starting point, that motion did fail. So it's going to have to be clarified is this as it is what's being voted on and what's going on, or is that memo included, which gives them the flexibility to make changes?
Can I move to add the memorandum? Is that in order?
Yes.
And I separated that because I thought it would be more helpful, but I should have just left it. Sorry.
Okay, so let's make sure that they get that written up correctly. As they're doing that, can you tell us what part of the memorandum specifically speaks to that flexibility again?
It's the first paragraph. It's the first part of the last.
Okay,
It's the
so where
last
it says
part of
it
the
is
first
drafted
paragraph.
for staff refinement and committee discussion, not as a final form.
Yeah, and if we wanted to change, it's now in board, so if we want to change that from committee to board, but it's probably just a technical error.
We have voted to include.
No, we included, there's two different things. There's a memorandum, and then this is a different document. So the memorandum that was adopted was the questionnaire and that process. This is a separate one called the Memorandum to the USBE Library Review Addendum Document. Okay. So it's another document. And AG Cooper, can I ask for clarification? Would this address your concern?
Yes.
Okay, thank you.
And I apologize on my end. My brain works in boxes sometimes, and I probably overcomplicated it by trying to oversimplify it.
Okay, let's make sure that this is the appropriate amendment that you're hoping for. Okay, so the motion is to include the memorandum to the USBE Library Review Addendum Document, Member Green, Draft 1 as part of the 2026 timeline plan, which clarifies that the additional documents are included for staff refinement and committee discussion, not as a final form. And do we have a second? Okay. Member Carey?
I thought the body had previously discussed that when we're going to reference a memorandum or an aid, that we include the date of that document. So I would just like to suggest that if we say we're going to include the memorandum, perhaps it's say memorandum dated August 4th, 2026, just to be consistent with our prior actions. Thank you.
Okay. Since this was a motion, a second, is there any objection to adding the date to be consistent? Okay. All right. So is there any discussion to this motion? Okay, seeing no lights, let's cue this amendment up for a vote. Who else? Member Booth, are you voting? Okay. All right, that motion does pass with 12 in favor, 1 abstention being Chair Hymas, and 1 no vote being Member Real. Okay, going back now to I think our original motion maybe we'll hit a record of the longest motion. Oh no. Guess we don't want that to be a challenge. I just want to make sure that we get all the information in that large amendment. Are we adding in that part that we just passed? I don't know who's driving now. We just need to add that motion piece that we just voted on, please.
It's gonna be cool. That's fine.
I think was there some additional language that clarified the flexibility or right, but it was in the motion to amend the motion. So it needs to probably say exactly what we had. Christine is going to love the grammar of this motion. She's trying not to make eye contact with the motion. Okay, so let me go ahead and state the motion, and we're almost at dinner time, so we'll get there. Okay, the motion is that the board adopt the 2026 timeline plan draft 1 as amended on second and final reading and appropriate $60,000 from board discretionary funds for implementation and include the USBE library review addendum revised and give staff the flexibility to adjust the timeline to meet the requirements, and that the instrument would be a starting point, and to include the memorandum to the USBE Library Review Addendum Document, August 4th, 2026, Member Green Draft 1 as part of the 2026 Timeline Plan, which clarifies that the amendment documents are included for staff refinement and committee discussion, not as a final form. Yeah, it's a quote from the document. Okay. Seeing no lights, let's vote. Okay. That motion passes 10 in favor, 1 abstention with Chair Hymas, and 2 no votes, being Member Reel and Member Lear. And with that, going back to you, Chair Carey from the committee.
That was the last item to be discussed from law and licensing. Thank you.
Okay, thank you. With that, it looks like we are ready for a dinner break. Okay, there's salads and sandwiches, so help yourselves. Yep, we did go from lunch to dinner. That time goes fast, doesn't it? So how long do you want to wait to start? Okay. Okay, we'll take about 15 minutes if you'll, board members, if you'll grab your food and bring it back here. We'll take about 15 minutes and then we'll get going and you can eat while we keep moving forward. Thanks.
Oh, yeah.
2, 5, 6, 7, 8, 9, 10. We'll count Jenny. All right.